Deputy McLeish.
Yes, Your Honor.
Do we have Mr. Stroud available? James Stroud?
No, sir.
We don't.
No, sir.
Okay.
I can get
Mr.
him
Stalka, if you'll approach. No, that's okay. I don't think we need him.
Okay.
This is cause number CR 1436, State versus James Michael Stroud. We were set for motion to revoke today. It's my understanding, and it's my recollection that I granted the motion to substitute Mr. Salcup. I've ordered that, and so I'm assuming you're not ready to proceed with a revocation hearing today?
No, Your Honor.
Okay. That's fine. So what I'm going to do is I'm going to reset Mr. Stroud. I'm not going to bring him up from the jail. And I'm going to reset him until September 30th. That's the next contested docket date. And so we'll go forward with a revocation hearing that day unless y'all have something worked out with the state. Okay, so I'm going to have this form right here. Brooke, you've already got that signed. All right, we'll bring this notice of setting to you. Nursing council. So if you'll just inform your client that we've reset the case. No, you're very welcome. All right, I'm gonna try to bring in Miss Lewis, Mr. Sanders. And you want to make sure your microphone's on, or you can come stand up here. Test. All right, somebody's audio is on. Is this laptop on again? Will you mute that laptop there? There's an echo repeat. And it may be in the lower right, the speaker, the lower right hand speaker down there. If you'll, if you'll X that out.
You want me to exit out?
I do want you to exit out. Yes. Test. Test, test. You double check that computer, make sure it's on. There was audio coming out of it. Just waiting for them to log in. I mean, they're logged in. I'm just waiting for them to get set up. All right, I do not see the Henderson County Jail logged in, so if we have someone that's ready in the, let's see, are you ready on Mr. Whitaker?
Well, I think we have the new judgment. I might need to make the change on the plea papers.
Yeah, I thought we were getting new plea admonishments. Here, if you want to mark through them, that's fine. All right, Mr. Whitaker, if you'll step on up. All right, Mr. Whitaker, I swore you in earlier this morning in cause number CR 21-199. Do you recall that? You understand that your testimony is still under oath? All right, so Mr. Whitaker, I believe that this morning we were discussing a plea bargain wherein you were going to go on deferred adjudication probation. And I was discussing that with you, and then you asked to speak with your attorney, and Mr. Sanders spoke with you and then indicated to me that you wanted some time to consider the other offer made by the state. And so now are you telling me that you wish to change your plea agreement and plead guilty to the offense in exchange for the state's recommendation that you are convicted of the crime, that you receive a 16-day county jail sentence under section 1244A, that you receive credit for those 16 days, and that you pay a $2,500 fine in restitution, court costs, and reimbursement fees? And you believe that you've had enough time to speak with Mr. Sanders about that, and you understand that if the court approves this and signs the judgment today, that when you walk out of the courtroom, you will be a convicted felon? You do understand? And you understand that you're still going to be obligated to pay the fines, court costs, and restitution? Okay. So Mr. Whitaker, understanding the revised plea agreement and the range of punishment, how do you plead to possession of controlled substance in penalty group 2 less than 1 gram? Are you pleading guilty because you're guilty of committing that offense? Has anyone threatened, forced, or pressured you to plead guilty? And Mr. Sanders, you've advised your client about the collateral consequences related to a felony conviction?
Yes, sir. We discussed all that.
And you believe that he's intentionally, knowingly, and voluntarily made this decision of his own free will?
Yes, sir. And this was something, a matter that we had discussed off and on throughout the process. Just have kind of gone back and forth quite a bit about the better way to go, all considered. Once they realized that this option you take is the better option.
Okay. Anything further from the state?
No, Your Honor.
Anything further, Mr. Sanders? All right, Mr. Whitaker, the court will find that there is sufficient evidence to convict you of this offense. The court will follow the plea agreement. Court hereby convicts you under section 1244A of the state jail felony offense of possession of controlled substance in penalty group 2, less than 1 gram. Court assesses your punishment at 16 days confinement in the Van Zandt County Jail. Court awards you credit for 16 days towards that sentence for time that you have spent in jail previously. Court orders you to pay a $2,500 fine, $180 restitution, and orders you to pay $35 reimbursement fee to Van Zandt County. Court takes into consideration under section 1245 DA 2021-150, possession of marijuana less than 2 ounces. So after you're fingerprinted and you leave the courtroom, I want you to go down the hall to the left and speak with Ms. LaPrade, court collection officer, so that you can make arrangements, payment plan. Are you paying any of it today? So I want you to be aware the court monitors the payment plans. And so if you miss payments and you don't respond and don't work in good faith to pay them off, they're going to bring me a warrant. I'm going to sign it. You understand? Okay. All right. If you'll come forward to be fingerprinted with the bailiff. The paperwork since probation's not here. We'll need to get a copy of all the stuff, give Mr. Whitaker a copy of his judgment, give it to Peggy, and then take him down to Bonnie. Thank you. All right, who do we have ready at the Van Zandt County Jail?
Your Honor, we have Mr. D'Angelo with Mr. Banks.
Austin William Banks, CR 19298 and 2019-358. Good afternoon, Mr. D'Angelo.
Your Honor, good afternoon.
Mr. Banks, how are you, sir?
I'm good. How are you?
I'm doing fine. Are we entering a plea today with Mr. Banks?
That's correct, Judge. He's pleading true to both the motions to revoke. We had one of the misdemeanor cases transferred to your court, and he's receiving 60 days in the Van Zandt County Jail with credit for time served as noted in the judgments.
And just because I don't have the judgments with me, Mr. D'Angelo, I'm going to ask for your assistance. Is
Yes, sir.
he's pleading true? I do have copies of the motions. Ms. Heisel's provided that to me.
I don't have copies of these
Oh, you
two,
did?
if you just would refrain from signing this
Okay,
copy.
sure. Never mind, Mr. D'Angelo. Ms. Heisel's got what I need.
Excellent.
All right, Mr. Banks, if you will, please raise your right hand. I'm going to place you under oath. Mr. Banks, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, let me put your hand down. You are Austin William Banks, is that right?
Yes, sir.
And Mr. Banks, in cause number CR 19298, you were placed on community supervision on September 15th of 2020 when you appeared before the court and pled guilty to a Class A misdemeanor offense of assault against an elderly or disabled individual. Court reviewed the evidence, heard the recommendations of the state and the defense, and the court assessed your punishment at 1 year confinement in the Vance County Jail and assessed a $2,600 fine. Court suspended the sentence of that 1 year and placed you on community supervision for 18 months. In cause number 2019-358, wherein you were charged with driving while intoxicated, a Class A misdemeanor. On that same day, the court assessed your punishment pursuant to a plea agreement at 1 year confinement in the county jail with a $100 fine. And the court also suspended that sentence and placed you on community supervision for a period of 18 months. It's been during your period of community supervision that the state has filed with this court a motion to revoke community supervision. Have you had enough time to review that motion or both motions in each case with your attorney, Mr. D'Angelo?
Yes, sir.
Do you feel like you've had enough time to discuss those with him, have all your questions answered?
Yes.
Is there anything about the paperwork that you've read over and signed that you do not understand?
No, sir.
And are you pleased with Mr. D'Angelo's representation?
Yes, sir.
Mr. D'Angelo, did your client waive the formal reading of the state's motion to revoke in each case?
Yes, Your Honor, I've provided him and reviewed with him a copy of the motions to revoke via a prior Zoom meeting, and he understands the allegations against him and waives formal reading.
And is it his intention to plead true to all counts in both motions?
That is correct, Your Honor.
All right. All right, so at this time, Mr. Banks, on the charge of assault against an elderly or disabled individual with respect to the motion to revoke, how do you plead to counts 1, 2, 3, 4, 5, 6, 7, 8? How do you plead to those? Are those counts true or not true? And I'm sorry, true?
True.
Yes, sir.
Okay, and with regards to the driving while intoxicated case, how do you plead to counts 1, 2, 3, 4, 5, 6, and 7? Are those counts true or not true?
True.
And Mr. Banks, are you pleading true to all of these counts because it is true of the conduct alleged that you committed, the conduct alleged in these counts?
Yes, sir.
Okay, so what's being alleged is true. Has anyone threatened, forced, or made you feel like you had to plead true to any count?
No.
All right, the court will accept Mr. Banks' pleas of true in each case. Mr. D'Angelo, any objection to the admission of the defendant's rights and plea of true?
Subject to our plea agreement, no, sir, Your Honor.
All right, the court will admit the defendant's waiver of right and plea of true in each case. Anything further from the state?
No, Your Honor, the rest of my-
Anything further from the defense?
No, Your Honor.
All right, in cause number CR 19298, court will find that Mr. Banks will find all counts alleged to be true. Court finds that Mr. Banks has violated the terms and conditions of his community supervision. Court will this day revoke his community supervision, assess his punishment at 60 days confinement in the Vance County Jail, will issue him credit for 54 days of time already served. Court will also order him to pay the balance of his financial obligations, including fine, court costs, and reimbursements. Towards this sentence, I believe that I've already announced that court awards him 54 days credit in that case towards his sentence. In cause number 2019-358, court will find the counts alleged to be true. Court will revoke Mr. Banks' community supervision for driving while intoxicated, will assess his punishment at 60 days confinement in the Vance County Jail, issue him credit for 55 days time served previously on this case towards that sentence, and order him to pay the balance of his financial obligations. Mr. Banks, you're hereby remanded to the custody of the Vance County Sheriff so he can carry out the terms and conditions of the sentence. Once you are released from the Van Zandt County Jail, Mr. Banks, I'm going to order you to report to the Van Zandt County Courthouse and meet with the court compliance officer so you can make arrangements to pay off what you owe. Do you understand?
Yes, sir.
Failure to do so is going to result in 2 warrants being issued for your arrest. Okay, so I'm going to have you go with the bailiff at this time and be fingerprinted.
Your Honor, thank you. Good to see you as always.
Thank you, Mr. D'Angelo. I appreciate you. Good to see you as well. We have anyone in the Henderson County Jail that's ready? What I want you to do is, you already took him down to see Bonnie? He just needs to go down to see Bonnie and set up his payment plan, and he's good to go. Yeah, give him, as long as he's got a copy of that judgment, and he can go see Bonnie, and then he's free to go after that.
But they weren't able to hear me.
Okay, there's Miss Lewis. Okay.
Yeah, thank you.
Yeah, I couldn't hear you or see you, Miss Lewis. Okay. This is cause number CR 17158, State versus Deborah Lewis. And to show that she is set for docket call today. Mr. Sanders, do you have an announcement?
Judge, I'm gonna ask if we could reset for one more docket call. I think she had just gotten arrested in July. We haven't been able to talk once, but I know there have been some COVID or quarantine issues. Because I think she wasn't able to come to work last time that we had said, kind of impacted being able to meet with her. So I was gonna see if we could reset a few weeks for one last docket call and make a decision by that.
Has an offer been extended to Miss? Okay, and what's that offer?
10 years fees.
10 years TDC? And
Sir,
Miss Lewis, were you able to hear Mr. Sanders?
yes, for, before when the offer was 5 years, what happened?
I'll let you and Mr. Sanders and the state talk about that. I'm not involved in their plea
Okay, thank you.
discussion, so I'll let Mr. Sanders communicate that to you.
Okay, thank you.
I'm going to grant Mr. Sanders' request for one last setting on Miss Lewis's case, and we will reset this. Are you available on September 16th?
Yes. Nothing over.
You already here? All right, so just be advised that Miss Lewis could still be in the Henderson County Jail. I don't know, I don't think there's any COVID issues, but I think she's just being housed there. So just know that she could very well be there. So Miss Lewis, we're going to reset your case for a few weeks until September 16th. And
Yes, sir.
Mr. Sanders will be in touch with you.
Oh, thank you, sir.
All right, you're welcome. And Henderson County jail staff, are they in there with you?
No.
Okay, just tell them I said I appreciate their help today.
Okay, I will.
Thank you, ma'am. I believe that's all we have in Henderson County. Is that all we have in Henderson County with just Miss Lewis?
Judge, I'm gonna head on down to the jail. I've got 2 folks down there.
Okay, thank you. All right, if we have anyone else available and ready to go at the Van Zandt County Jail, I'm ready.
Mr. Schmidt is ready with one of his clients.
Okay. Who are we ready on, Mr. Schmidt?
This is Joshua Hand, CR 21-00168.
All right. This is set for is this an evidentiary hearing today, or is my docket says pre-trial, but I don't know if that's correct.
No, sir, it should be a motion for bond reduction.
All right, let me pull that up real quick. Are we also set for pretrial? I'm looking back on my notes. Surely he was set for pretrial August 12th. Did we have a pretrial announcement that day, Mr. Schmidt?
Judge, I subbed in for prior counsel on that date, and I asked for an additional pretrial. After that, I'd also filed a motion for bail reduction. I do know that if we do have a pretrial date set today, when I was in court previously, requested the discovery. I requested the discovery through the portal as well. I still don't have any of the discovery, so I would need to know the pretrial in the event we were set for that today anyway.
Okay. All right. Well, I believe that we are. So I'm going to go ahead and reset you for an additional pretrial, and if the state can look into the discovery portal issue with Mr. Schmidt, make sure that he has discovery. And I'd be looking at September 28th, Mr. Schmidt. Do you know if you have any conflicts that date?
So that's fine, Judge.
All right, so we'll go ahead and set Mr. Hand for pretrial on 9/28. And then we'll go ahead and take up the motion to reduce bond.
Judge, to begin with on our motion, I don't know if you have access to the motion right now, but it
I do.
appears based on Mr. Hand's book-in that he is booked in on 7 different charges, all arising out of a offense date of November. He is indicted on one of those, and that is the case CR 21-00168. So currently he's being held on a cumulative amount of $170,000 worth of bonds. It's my, based on the time, I would argue that he's entitled to a PR bond on all of those cases, because I believe none have been filed or indicted, but CR 21-168. And so we would argue to start with, based on delay on all of those cases, that he would be entitled to a PR bond. In addition, on the CR 21-00168, we would provide testimony requesting that his bond be reduced.
I'm looking at your motion, and the second entry says evading arrest or detention with a vehicle, surrender of principal.
Yeah, and Judge, I looked at that as well and talked to Mr. Hand. It looked duplicative to me, or that, in other words, it's difficult for me to imagine how an individual could receive 2 separate charges of evading arrest with a vehicle on the same date of offense. And I do see the SOP on there, and I do know that there was a surrender at one point in time. But I'm uncertain as to whether or not those are duplicate entries on bookends and they didn't withdraw the prior bonds, or if they're just, if they're separate offenses. I'm going forward today as though they were separate offenses, because that's how he's booked in and being held.
Sure. And I see that the remainder all have SOP at the end of them. So does that mean that upon arrest, he was admitted to bail with a surety and then ended up back in jail on a surrender, and then the 90 days ran? Or
I believe that he was in jail, bonded out, and then there was a surrender at one point in time.
okay. So of these 7 charges, he's indicted on 1, and that's should be the first one, evading arrest or detention with a vehicle. And then there's a question remaining on whether he's being held on a separate charge of the same title, but with a surrender of principal.
I believe so, Judge. And some of these charges are obviously misdemeanor charges that I don't know that they've been filed. I haven't received any information that they've been filed with court or court proceedings ongoing. So we've got at least 3 misdemeanors and 4 felonies, only 1 indicted.
Okay. All right. I'm ready.
All right. And Judge, I would call Joshua Hand and provide brief testimony.
Mr. Hand, if you'll raise your right hand, please. Sir, do you swear that the testimony you give to this court will be the truth, the whole truth, and nothing but the truth, so help you God?
So Your Honor.
All right, you may put your hand down. Make sure you speak up loudly and clearly. You're not just talking with Mr. Schmidt, who's standing, 18 inches from you. I've got a court reporter here that needs to hear you, and I need to hear you. So make sure you speak up loudly and clearly. Go ahead, Mr. Schmidt.
Thank you. State your name for the record. Joshua Hand. And you're currently being held on what appears to be $170,000 worth of bonds, correct?
Yes, sir.
And out of, you've got 1, 2, 3, 4, 5, 6, 7, 8, 7 charges listed in your book. And are those 7 distinct charges that you're aware of?
Yes, sir.
Okay, so there's 7 distinct charges.
Yes, sir.
And you're indicted on one case, and this is the CR 21-168 evading arrest.
Yes, sir.
Have you been indicted or has an information been filed on the misdemeanor charges that you're aware of?
No, sir.
And you were originally arrested back in November of 2020, correct?
No, sir.
Okay, when were you arrested?
I was arrested February 22nd on the charges from November 14th. I was taken care flighted to a hospital and I didn't get turn myself in until February.
Okay, so ultimately you were taken into custody in February on an offense that allegedly occurred in
November. Yes, sir.
Got it. Now, as far as all of the charges except for the indicted charge, are you asking the court to allow you to post a PR bond on those
Yes, sir.
as they're not indicted and the state's not ready for trial?
Yes, sir.
Now, on the one that is indicted, that bond amount appears to be set at $50,000. Are you able to, let's start with, are you able to post $170,000 worth of bonds?
No, sir.
Do you have family members that would aid you in posting bond in the event this was reduced?
Yes, sir.
And where do you live when you're not in Vance County Jail?
I live with my fiance on 8220 Diane Drive, and then in Kaufman, Texas, 75142. And my grandmother within 5 miles of her.
All right, so your grandmother and your fiance are within that short distance of each other.
Yes, sir.
And do you have reliable transportation to get back and forth?
Yes, sir.
Okay. Do you have any property or assets that you could put up to post this $50,000 bond?
Yes, sir.
And do you think that if the court reduced that, you would be able to post a surety bond? That means pay a bondsman
Yes, sir.
to bond you out on that one.
Yes, I do.
And do you think that if the bond was set around $25,000, you could make that?
Yes, sir.
Okay. And as far as court dates, future court dates, so far, I think that all of your court dates, you've been in custody so far on this case, right?
Yes, sir.
If you were released, you'd be under conditions of pretrial release. You're aware of that.
Yes, sir.
And you're aware that if you did not make it to a court date, that the bond would be revoked and you'd be right here again. Right?
Yes, sir.
You assure the court that if he reduces your bond and you're able to bond out, that you would make all court appearances.
Yes, sir.
Pass the witness.
State, any questions? Thank you, Mr. Woodward. You'll need to come forward.
Just getting ready to do it back there.
I'm gonna say, go ahead and bring that microphone with you. It'll help.
Mr. Schmidt, can you hear me?
Yeah.
Mr. Hand, you've previously made bond in the indicted case. Is that correct?
Yes, sir.
I'm sorry, what was that?
Yes, sir. I have.
And that bond was active on 6/18 when you were arrested again, correct?
No, sir. But I was under the illusion that it was an indictment. I was under an illusion that they told me it was a indictment warrant.
Okay. Mr. Hand, were you arrested for a new evading charge or you were arrested on a warrant for an evading charge?
They said it was a warrant for an evading charge that I already was on bond for.
Okay. And when you made bond, and when you were arrested on that warrant, your previous bond company went off your bond, is that correct?
Yes, sir. Within a week to 2 weeks in Van Zandt County, they SOP'd.
Okay, and that bond was for $50,000, correct?
Yes, sir.
Have you contacted them about reinstating that bond or anything of that nature?
No, sir. They do not have a number that allows collect calls to reach.
And so your testimony is that you would not be able to make a $50,000 bond, but you would likely be able to make a $25,000 bond. Is that what you testified to?
Yes, sir.
Judge, I have no further questions.
Judge, I had some follow-up questions.
Okay, go ahead.
Mr. Hand, I think you testified that your understanding was that you were arrested on after indictment warrant, is that correct?
Yes, sir.
And when you were arrested on the after indictment warrant, was it for an offense that occurred at the same time all the rest of these
Yes,
occurred?
sir.
So the surrender of principal was not in response to a new criminal
No,
offense,
sir.
correct?
No, sir.
So once you were arrested on the after indictment warrant, based on your understanding, that's when your bondsman went off the bond.
Yes, sir.
And do you think, and I'm still a little bit unclear, but do you think that when you look at your book and the evading arrest with the vehicle that said it's 50,000 is this indicted case, and the evading arrest surrender of principal is the same case?
Yes, sir. I do.
So you think it's a double book,
Yes, sir.
and you think that it occurred based on an after indictment warrant?
Yes, sir.
But you did not commit a new offense while on bond.
No, sir.
And were you in compliance with your bond conditions through your bondsman while you were there?
Yes, sir.
So based on your understanding, the reason they surrendered was based on an after indictment warrant.
Yes, sir.
But all occurred in November of
Or,
2020.
yes, sir.
Passed away.
Hey,
Further questions, Your Honor?
And Judge, I don't know if you heard Mr. Hand's testimony that he was transported to the hospital on the date of the incident. And so it wouldn't surprise me that an after indictment warrant was issued, but was in conflict with the bonds that he already been arrested on. As more of a, and I can't confirm it, but as more of a clerical error than anything else.
yeah, I'm kind of confused here because I'm viewing the clerk's record in CR 21168. And he posted a surety bond, a $50,000 surety bond with discount bail bonds. And then that was March 9th of 2021. And I showed that he was indicted 5/28/2021. And there was a request for an after indictment warrant. And the warrant was issued and I set bail at $50,000. So I'm kind of confused as to what he posted bail on if he wasn't arrested and we needed an after indictment warrant.
I don't show that he was, I showed that he posted bond with ever actually being booked into the jail. So we don't know where that original bond, it's not attached to an arrest because he wasn't arrested. He went to the hospital. He turned himself in, but I don't show a book in for when he turned himself in, and I believe he testified February.
Let's look here and see. So it appears that he was arrested in Kaufman County. Is that right? Is that right, Mr. Hand? Were you arrested in Kaufman County?
Yes, sir.
And you posted this $50,000 bond with discount bail bonds for evading arrest, previous conviction. Okay, so let's look here. So he was admitted to bail before he ever made it to Van Zandt County. So there's no tracking number for him, but he was already on bond. Let's see here.
So Van Zandt County had no idea that he had previously been arrested and admitted to bond when we issued our after indictment warrant. And then once he's in jail, his bond company surrenders him based on that new arrest, because likely they didn't know that it was not a new offense, just like we're kind of sorting through.
They surrendered him in June.
I believe it's June 16th, which is the same day that he was arrested on the warrants. I believe in Kaufman County, correct, Mr. Hand?
Yes, sir. I was arrested on the 16th. Yes, sir.
So I'm trying to wrap my mind around this. He's arrested, he posts bond in Kaufman County, he's released, goes to grand jury here.
We have
After indictment warrant issues, he gets arrested on the same charge. He gets booked back in, and then the Kaufman County bail bond surrenders him on the same charge that they bailed him out on.
Yes. I don't know if they believe that to be a new charge or, because they don't actually give a reason, as far as I can see. It just appears that he is in Kaufman County Jail, so.
Well, it appears to be a surrender rather than a release of surety. So they're surrendering him on his subsequent arrest, which shouldn't have occurred. It shouldn't have occurred, and then there wouldn't have been a surrender.
I would agree with that, Judge.
Now it says here that the original bond was 25,000. That seems to be in conflict with what I've seen. Mr. Hand, did discount bail bonds post bond for you and all the other charges that you had as well?
Yes, sir. They posted every bond. Yes, sir.
And I think Mr. Woodwalk asked you, have you been in contact with them to see if they would go back on your bond?
Not since my incarceration, no, sir.
And so Mr. Hand has not committed a new offense he has committed a new offense or been arrested on a new
It
offense?
appears to the state at this point not. It appeared to us previously that he had, based on what Mr. Schmidt had put in his motion in our reading of this. I have requested any additional information and not heard back from the sheriff's office. That is theoretically, if it is a new third degree, it's within 90 days. They're within a certain time period that we would expect that they may not have a full case to us. But I've heard nothing new about a new offense. What he's saying appears to follow what the documents we have, Judge.
Okay.
Obviously, just if I might, state would be unopposed to a PR bond on all of the misdemeanors. They are the surrender of principal. They appear to be well past at this point, even though he's previously made bond. We are still not ready. We do not plan on charging those given the nature of the other charge. Other one charge, it appears. We thought there were two, just one.
And Mr. Hand's asking for a $25,000 bond on the indicted evading arrest. Do you have a position on that?
Given that there is not a new offense, state would not be opposed to $25,000 bond, a bond reduction to $25,000 on the indicted case, Judge. I don't.
And Judge, if I might, it seems to me that if Mr. Hand was surrendered based on an after indictment warrant that he'd already posted bond for, that we would ask that the state agree and that the court realize that he shouldn't have been surrendered in the first place, and to require him to post an additional bond after having posted the bond. I mean, I understand errors occur, especially in cross-county traffic as far as the paperwork is concerned. But having been arrested on this offense posted bond, and they only surrendered because of an after indictment warrant for the same offense he'd already been arrested on, we'd ask that you allow him to post PR bonds on all of those. There's no evidence that he committed any new offenses, and it looks to me like he's in custody simply because of paperwork error.
So I thought the previous request was for 25,000 though.
It was, Judge, but in our motion, you'll notice that a reduction or a PR bond was requested. But it took a minute of testimony in the court, looking through the court's file, which I don't have access to, for it to come to fairly clear to me, and I believe to the state, that the surrender shouldn't have occurred based on the sequence of events unless there had been a new offense, and it doesn't appear that there has been. So based on the testimony and the conversations between the state and the court and looking at those documents, I'd ask that he be allowed to post a PR bond instead of a surety.
And Mr. Hand, you said that you went to the hospital. Why did you go to the hospital? Was it as a result of evading arrest and a wreck?
And Judge, I would object to the court asking my client that question at this time. This is a bond hearing, and that goes to the substance and foundation.
Well, I understand. Well, I understand, but you brought that to my attention. You said, I don't know if you heard Mr. Hand say that he went to the hospital. So I was just trying to clarify if that was medically related or if it was something to do with the offense.
Judge, it was medically related.
Okay, so it has nothing to do with community safety and evading arrest in the vehicle.
I'm not saying that to the court, nor am I relaying that to be a fact. I do know that on the same day of the offense, he was transported, and it was brought up to the court's attention because of the difference between an after indictment warrant being issued well after the fact and those bonds being miscommunicated had he been arrested on the spot for the alleged offense.
I understand. Okay, so the court will grant personal recognizance bonds for the unfiled, either if they're misdemeanors, unfiled with informations, or if they're felonies and they're unindicted. Court will grant PR bonds for those. Court will find that $50,000 is excessive and unreasonable considering the facts of the case. The court will reduce bail to $25,000 for the indicted case of CR 21-168.
Judge, if I might, state would also request I'm trying to figure out the best way, because obviously the bond amount, I don't know how he is booked in, because he has an evading arrest with vehicle and an evading arrest with vehicle surrender principal. One of those clearly should not exist. Let me contact, state will figure out how to get him released on that as soon as possible. I will state that for Mr. Hand and Mr. Schmidt's information. I don't believe giving him a bond on that is proper because it shouldn't exist. There shouldn't be a bond. So let me figure out how we can get him released on whichever one is not the indicted case that he will have a bond on, and make sure the other one is disposed of and closed, as it clearly should not. It appears to be it should not exist.
And that's fine. I just don't want there to be any barrier to him being released. If he's prepared to post a $25,000 bond this afternoon, I don't want to hold him over. So we try to figure out the administrative part of why he has a SOP on the same. I don't want that to prevent him being freed on bond. So to the extent that that's not figured out, then we'll just call it a PR bond and grant it. And later, if that goes away, then the bond goes away with it.
Okay, and Judge, if you'd like to do that, that is absolutely fine with the state. If you'd like to set a $25,000 PR bond on the other one, just so we make sure there is no impediment, and then we can just try to get that resolved and have it taken care of. That state is absolutely okay with that, just so we don't, I'm trying to make sure he's not held on something else that is not handled today.
I think we're on the same page.
Yes, Judge.
Okay, so I'm going to go ahead and just grant PR bonds on everything else except CR 21-168.
That works for the state.
And that way the jail can clear out, they can release Mr. Hand, and then we can figure out the booking issue
So
later.
we're only going to hold him on one $25,000 cash or surety bond on the indicted case. Everything else will be a PR.
Correct.
Works for the state, Judge.
Okay. And so we'll see Mr. Hand back. So Mr. Hand, if you post bond in this case, then we'll see you back on September 28th for pretrial at 9 a.m. in the courtroom here at the courthouse. If you don't make bail, then we'll come to you at 1:30 at the jail. Do you understand?
Thank you, Your Honor.
You're welcome, sir.
And Judge, previously, I was in court this morning, got here looking for plea paperwork on Bobby Montgomery. Apparently there's been some miscommunication. I came to the courthouse to get it. And we just got it now, so we'll get it together. Thank you.
Okay, you're welcome. I got a copy. So yeah, take your time, and whenever you're ready, let me know. I've got a copy here as well.
Thank you, Judge.
Who's next?
Well, we had nobody ready. However, we do have Ms. Sotelo up here. If you would like to arrange a breakout room for her and Mr. Ashmore to go over papers while Mr. Schmidt does the same with his client.
Absolutely, I can do that. Now, you made up too. Do you have another device for her to go to in the breakout room?
I do. But if we don't have anybody ready to present to the court, and if Mr. Schmidt needs to take this time to visit with his client, can Mr. Ashmore also visit with her in here, or do they need to be separate?
If nobody else is going to be ready, you can use the main room, unless Mr. Ashmore has an objection. I don't know if he does. And as a matter of fact, he was just logged in, but he's gone now. I don't see him.
Because I do have an investigator who's willing to work with me to use these separate devices in separate locations, but she's the only one, and she's juggling a little bit today as well.
All right, so I'll just, I'll put the jail court there on the breakout room with Mr. Ashmore, and then since Mr. Schmidt's there, he can visit with his client, same time.
Okay, thank you, Your Honor.
You're welcome.
I'm gonna break this here, so if you'd like to stay, I just want you to be aware. All right, let's get you up in front of the camera. Hopefully we're gonna get your attorney connected with us. So I'll break that. Your Honor,
Yes, ma'am.
I believe Mr. Ashmore is ready with his client, Ms. Sotelo.
Are we doing a plea for Ms. Sotelo today?
Yes, Your Honor.
So you've already gone over all of the paperwork with her?
Yes, Judge.
All right, and have you already signed all of the plea paperwork, Mr. Ashmore?
I have, Your Honor.
Okay. All right, Mr. Sotelo, I'm sorry. If you'll raise your right hand, I'm going to place you under oath. Ms. Sotelo, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you put your hand down. Make sure you speak up loudly and clearly so I can hear you. My court reporter can take it down. Ms. Sotelo, you appeared before the court. Oh, hell yeah. Yeah, hang on, we'll have to get my court reporter. Sorry, I thought she was sitting there.
Judge, do you have this Sotelo paperwork with the terms?
Hmm?
You have the paperwork.
I do. Good catch, Mr. Woodward. Hang on, Ms. Sotelo. Once my court reporter gets back, we'll,
We're just going without you.
sorry. This monster.
Hey, guy.
All right, Ms. Grisham, we are going to go on the record in CR 16437, State of Texas versus Basil and Sotelo. All right, Ms. Sotelo, if you'll raise your right hand again. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. All right, Ms. Sotelo, you appeared before the court on December 19th of 2017. You pled guilty to the offense of possession of a controlled substance in penalty group 1, less than 1 gram, that being a state jail felony. Court heard the evidence, found that there was sufficient evidence to convict you, and the court assessed your punishment, found that there was enough evidence to convict you, and did convict you, and assess your punishment at 2 years confinement in the Texas Department of Criminal Justice State Jail Division, and ordered you to pay a $1,500 fine. On that same day, the court suspended that sentence, placed you on community supervision for a period of 3 years. It was during that period that the state filed a motion to revoke your community supervision. Have you had an opportunity to review that with your attorney, Mr. Casey Ashmore?
Yes, sir.
Do you feel like you had enough time to discuss the case with him, have all your questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
Yes, sir.
And did you sign with your true and correct signature only once you were confident as to what you were signing?
Yes.
And Mr. Ashmore, do you believe Ms. Sotelo to be competent today?
Yes, Judge, I do.
And I see here that the plea agreement is that Ms. Sotelo is going to plead guilty to all counts contained in the motion in exchange for the state's recommendation that supervision be revoked and confinement be assessed at 12 months in the state jail division of TDC, in addition to reimbursement fees of $500. She would also receive 365 days credit towards her sentence in this case. Is that your understanding, Ms. Sotelo?
Yes, sir.
All right. And Mr. Ashmore, does your client waive the formal reading of the state's motion to revoke?
We do, Your Honor.
All right. So Ms. Sotelo, understanding the plea agreement, let me ask you, how do you plead to counts 1, 2, 3, 4, and 5 as contained in the motion? Are those counts true or not true?
They're true.
And are you telling me that they're true because in fact they are true and you committed the conduct alleged in those counts?
Yes, Your Honor.
And Ms. Sotelo, has anyone threatened, forced, or pressured you to plead true to any of these counts today?
No, sir.
All right, the court will accept Ms. Sotelo's pleas of true at this time. Mr. Ashmore, any objection to the admission of the defendant's waiver of rights and plea of true?
No, Your Honor, thank you. And I apologize to the court for not being there personally.
I appreciate that.
And Ms. Sotelo.
The court will admit the defendant's waiver of rights and plea of true into evidence. The court will take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we've rested close.
Any further, Mr. Ashmore?
No, thank you, Your Honor.
All right, then based on Ms. Sotelo's pleas of true and the evidence presented, the court will find that she has violated the terms and conditions of her community supervision. The court will follow the plea agreement in this case, will revoke her community supervision, assess her punishment at 12 months confinement in the State Jail Division of TDC, and order her to pay the balance of her financial obligations, including a $500 reimbursement fee. Ms. Sotelo, you hereby issued 365 days credit towards your sentence for time previously served in this case, and you're ordered to step over and be fingerprinted on the judgment. Once you are released from TDC, I'm going to order you to report to the Van Zandt County Courthouse so you can make arrangements to pay off the $500 that you owe. Do you understand? Okay, failure to do so will result in a warrant being issued for your arrest. So I'm going to have you step over with the bailiff at this time.
All right.
All right, is this Mr. Montgomery?
It is, Judge.
All right, this is CR 1428, State versus Bobby Ray Montgomery. And Mr. Montgomery, if you'll raise your right hand, sir, I'm going to place you under oath. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you may put your hand down. Mr. Montgomery, you appeared before the court on December 16th of 2014. You pled guilty to the second-degree felony offense of burglary of a habitation. The court heard the evidence, found there was sufficient evidence to substantiate your guilt. Court followed a plea agreement on that date and deferred a finding of guilt and placed you on community supervision for 4 years. It was also during your period of community supervision that I believe that the term of supervision was extended, and during that term, the state filed its motion to adjudicate and revoke your community supervision. Have you had sufficient time to review that motion with your attorney, Mr. Schmidt?
Yes, Your Honor.
Have you had enough time to discuss it with him? And do you feel like you understand everything that you've read and signed today?
Yes, Your Honor.
And are you pleased with Mr. Schmidt's representation?
Yes, Your Honor.
Mr. Schmidt, do you believe Mr. Montgomery to be competent today?
I do, Judge.
And does he waive the formal reading of the state's motion?
We waive.
And is it his intent to plead true to all counts?
It is, Judge.
All right, Mr. Montgomery, I see the plea agreement is that upon your plea of true to all counts, that the recommendation is to convict you of this offense, to revoke your community supervision, and assess your punishment at 3 years in TDC in order you to pay the balance of any monies that you have left owing, and that you would get 86 days credit towards your sentence. Is that the plea agreement as you understand it?
Yes, Your Honor.
All right, so Mr. Montgomery, let me ask you then, how do you plead to counts 1 through 6 as contained in the state's motion? Are those counts true or not true?
True.
And Mr. Montgomery, are you pleading true because they are true and for no other reason?
Yes, Your Honor.
And Mr. Montgomery, has anybody threatened, forced, or pressured you to plead true to any count today?
No, Your Honor.
All right, court will accept Mr. Montgomery's pleas of true to all counts alleged in the motion. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights, plea of true?
No objection.
All right, that's admitted into evidence, and the court takes judicial notice of the judicial confession. Anything further from the state? From the defense?
No, sir.
All right, Mr. Montgomery, then based on your pleas of true, the court's going to find the counts to be true. Court's going to find that you have violated the terms and conditions of your community supervision. Court will follow the plea agreement in your case. Court hereby adjudicates you, convicts you of the second-degree felony offense of burglary of a habitation. Court revokes your community supervision, assesses your punishment at 3 years confinement in the Texas Department of Criminal Justice, orders you to pay the balance of your financial obligations. Court awards you 86 days credit towards your sentence in this cause for the time that you have spent in jail. Mr. Montgomery, once you are released from jail, just ask that you report to the courthouse to finish paying off. Shows you only owe $70, so that shouldn't be very hard to pay off once you get out of jail. All right? So if you'll step over with the bailiff to be fingerprinted, good luck to you, sir. Mr. Schmidt,
Sir,
are you going to send over a motion to pay hard copy or any file?
I've got a hard copy with the signed documents that Mr. Montgomery did.
Okay, good.
You didn't do anything.
Yeah, it's front and back print, but
Let's just.
very, very, very brief.
Your Honor,
Yes.
we do have another one of Mr. Ashmore's clients up here if he's available.
Okay, does he need to go into a breakout room?
I don't believe so. Motion to withdraw to discuss with you.
I didn't hear that.
I'm sorry, it's a motion to withdraw. He has to present to you. Mario Hobson.
As soon as Mr. Ashmore gets logged in, we'll take that up.
Yeah. Sorry, Your Honor. Sorry about that.
Oh, no problem. All right, Mr. Hobson, step up. All right, this is cause number CR 21-123, State versus Mario Hobson. I believe that we're set today. What do we set for? Attorney status, motion to withdraw, motion for bond reduction. Does that cover it?
Yes, Judge.
Give me just 1 second. Let me pull up his case, if you don't mind, sir.
And Judge, I may have to switch the camera off for a second so I can look at my notes because I'm on my mobile device, just so I can refer to things. So I'll apologize for that in advance, Your Honor.
Remind me what we did. So we saw Mr. Hobson a couple days ago. Is that right?
July the 13th.
13th.
Before then was June the 1st.
No, that was pre-trial in July. Then we had a docket call on 8/24, which was reset to today. All right, so before we get started on all these motions, let me ask the state, is there an offer that's been extended to Mr. Hobson?
I can speak to that, Your Honor.
Go ahead.
Judge, this actually is Tonda Curry's case, the elected district attorney of the county. And the first offer we got was, and before I jump into that, I need to make sure that it's clear on the record that I believe what Mr. Hobson, my client, is asking for today is an express waiver of attorney-client privilege. But as the court is aware, he's involved, however related, in a shootout in a church parking lot in Van Zandt County in the middle of the night, or late at night, or early in the morning. Doesn't really matter. I'm not going to get into those semantics, but he's a Tennessee resident. There were 2 offers made, one of which was cooperation to permit him to tell the investigators in this matter some details about their allegations in the case and help fill in some gaps. And once that was, any effort with that was presented and rejected by Mr. Hobson, and offer of, I believe, 20 years. I believe our office received a letter which we've shown to Mr. Hobson of 20 TDC.
Okay, so
So two offers, one of which was help us with the investigation. The second of which was a jail offer.
okay, and was there an offer, the one offer that, I'm gonna wait for this emergency vehicle to pass, but the one offer of cooperation, did it have a term attached?
No, just no express overture of this will result in a deferred probation or a probation offer, but certainly some assistance with the investigation. And I have to be very careful because, as I understand it, there are two other co-defendants who may or may not be cooperating with the investigation, and in this and other counties, because I believe this this doesn't just involve our county. I think one of the defendants was arrested in Henderson.
And that's fine.
It could be
I don't-
Smith. I'm not sure.
That's fine. That's fine. I don't need to know that. So, all right. So some offers have been extended, and we were set for docket call, I believe, on the 24th. And I think that's also set today. So I wanted that to be on the record. And so, Mr. Hobson, I've received your defendant's concerns with court-appointed counsel. I've read through them. The only thing that I find that I want more information on is your statement that you said that Mr. Ashmore has not acted like your attorney since he had the job, and he has not done anything to get my life back on track. With regards to him not filing your motions for bond reduction, I don't find that rises to a level to have Mr. Ashmore removed if he makes a legal decision not to seek a bond reduction. However, I do want you to tell me why you believe he has not acted like your attorney since he's had the job.
I was extradited back here from Tennessee to clear my name. I have the bullet still in my arm on this, and it's like everything that I said it's one of deaf ears also. I'm here to clear my name, and I have no felonies, no warrants. I have 3 kids. I just try to go home. I'm actually here, and it says I'm marked as a Hispanic, which I'm African American. I have a home, and I have received all the letters to say come to court, and I'm just asked to go home until they get the trial ready, and I can come to court, for the bond reduction. I'm a law-abiding citizen myself, and I just feel like I've been here 9 months now, and I was at home, and it's no problem for me coming back into get this situation under control. Courts are standing up in trial and taking what the state sees fit for the case. Once they find out the evidence against me is fraudulent, and I'm not the guy, for this.
Well, Mr. Hobson, you told me a lot of things right then, but you haven't told me anything about what Mr. Ashmore has not done to act like your lawyer. I need you to focus.
I'm sorry.
Go ahead.
Like on June the 1st, when I got indicted on May the 6th, my bond, when you came in on June the 1st, it was $200,000. Okay, when that was over with, it said it's supposed to go and match my indictment to $100,000, which would have been a bond change. It's still sitting at $200,000 now after another 90 days. That was June the 1st, and it's August the 26th. It's it was already ordered, but it was never filed with the courts. So I asked him about that. So he said, "I'm not your bond." I said, "You're my attorney. I mean, if you're supposed to make sure my rights are getting taken care of. Where's the paperwork on getting this filed and making sure that I can get back to my family, and we can do this just like if I'm ordered to come to court, I can show up to court. There's no problem. I'm working. I'm 39. I turned 39.
Listen. I'm not taking up your motion to reduce bond right now. I'm asking you to address why you don't want Mr. Ashmore. And so he hasn't done a bond reduction at the time that you wanted him to. What else has he not done? You said he's not acted like your lawyer since.
I filed the paperwork.
legal aid has to file, you know, and it never got done. Even from April, when he first got my case in April, you know, I figured that what the attorney would do to help me get back to my life and my kids, and he's not. It's like whatever the case has said is the truth, and I just said my story, and on those pleas, he said, "Help me." I'm helping myself by saying what I know is true, and he's not listening to that. It was, whatever the paper said was right, and what I'm saying is wrong. That's why I feel like he's not in the best interest of me being free. So.
Well, I've been reading this, Mr. Hobson. Is this what you're talking about?
Yes, sir. Yes, sir.
So he's filed a motion to reduce your bond. Is this what you're talking about?
Yes, sir. I didn't know if he was dropped the case or not. I hadn't heard anything since
Well,
July
I
15th.
understand. He can't drop the case. Okay, let me explain something. Let me explain something to you.
Yeah.
Mr. Ashmore is on the court-appointed list for attorneys to represent individuals like you who claim to be indigent and meet legal requirements. He's appointed to the case. He stays on the case until I tell him he's off the case. So he can't drop the case. He can't drop you. If he wanted to withdraw from your case, he would have to give you notice, and we'd have to have a hearing, and I would have to give him permission to do that. Now, he's filed a motion to reduce your bond. And so I don't see any legal reason to remove him as your attorney. I don't see any written reason, and I haven't heard any reason from you today. Is there anything else that you think proves that Mr. Ashmore is not fulfilling his legal obligations and requirements in your representation?
That's the only thing is, you know, I've been sitting here for 9 months, and I was talking to him, and I thought we was on the same page for just getting me back to, you know, living my life. I still have the bullet in my arm trying to get the medical attention, and the coroner is still alive. So, I mean, that's the only thing. I just want to go on. I can show up to court whenever you're ready for me, and get this over with. I mean, you know, I'm at the mercy of the court, sir. Thank you.
All right. Mr. Ashmore, do you want to respond to Mr. Hobson? I'm not asking you to. I'm just going to give you the opportunity.
Yes, Judge. Real quick. Sorry, I had to move. I'm just trying to, I thought I was parked in a secure area, but I'm not, but I'm sorry. So look, Mr. Hobson meets no statutory requirement for a bond reduction. He's not a resident of the state of Texas. He doesn't have any contacts, any sufficient contacts in the state of Texas. He does not have any significant family members in the state of Texas. We have asked him through his spouse, who's been in touch with both your office and as I understand it, in a not very pleasant way. And it took us some time to get him and his wife under some level of control where they weren't calling and being discourteous to the people who are in charge of his freedom. But they eventually did, you know, understand that battling with the court staff is not going to help move the needle on his request for bond reduction. But statutorily, he has no sufficient contacts nor sufficient money with the state of Texas. I am going to ask to refer to my notes, so I do need to go away from the camera for a minute. You should be able to hear me. Judge, you know, the timeline, we've got one, two, three different visits to the Van Zandt County Detention Facility very quickly after his case was assigned, talking to him about the facts of this case, getting the information, showing him the information that we would need to show the court that there's sufficient reason to maybe even consider a bond reduction, considering you got an out-of-state defendant with insufficient financial resources and anything else. And I'll just say this, it's been a struggle with Mr. Mario on all of the things, not everything, but all the things. And, you know, that being said, I've explained to him multiple times he doesn't meet the statutory requirement for any kind of bond in the state of Texas. Other than a bail bond, which he has been offered, and what I understand is the financial number that he and his wife can afford is $1,300, which is nowhere near what the court has considered now 2 times, once from the state and once in a verbal motion that was raised by Mr. Hobson and myself, where the state reconfirmed the issue of the bond amount. So the fact of the matter is, I think the court has addressed this.
And what is Mr. Hobson's current bond amount? State, do you know?
Judge, I show it's 100,000.
And that's the same bond that Mr. Ellison was granted, co-defendant. I believe he posted his.
And like I said, I don't own any houses, but I do work. And if you could lower it, I can. I have a job to go to, but like I say, I just I'm not saying I'm not trying to run. I want to get this out the way, but if I can get that lower where I can make the bond, I will show the court. There's no doubt. I don't want to be picked up at a football game with my son and have to worry about this coming to haunt me. I will show the court if that's granted, sir. I do have family in Dallas. I just found that out since I got here since I've been incarcerated. I have a first cousin that's here in Dallas, but I would show up a day before the trial and be ready to come to court if I'm released or get a bond reduction, sir.
So you didn't even know you had family in Texas, but now you're going to go stay at their place? And
No. I said if I get released, then I will come back the day before to make sure I'm on trial, on time for the trial. If I get a bond reduction, and I can make it at that point, sir. I will not miss court, and that's for sure, for a fact.
Mr. Hobson, I see that you're indicted for a first-degree felony offense. I find that $100,000 for that type of offense, it carries a range of punishment of 5 to 99 or life. And I've reviewed the indictment and the allegations therein and find that that's not excessive or oppressive. Find that that's also consistent with what your co-defendant, so you're not being treated any differently. So the court's going to deny your request for a motion to reduce your bond. The court's also going to deny your request to have Mr. Ashmore withdrawn as your attorney. And so I'm going to tell you that Mr. Ashmore is your court-appointed attorney. And so you don't have to like him. He doesn't have to like you. But it's in your best interest to get along and try to work your case together so that he can provide you with his knowledge, his legal knowledge and expertise, so that you can formulate a defense to this case that the state's bringing against you, Mr. Hobson. That's the advice that I want to give you today. If you and Mr. Ashmore can't get along, then I will reevaluate. But at this time, I don't see a legal ground to have Mr. Ashmore withdrawn, and he's certainly not asking to be withdrawn from your case. I hear him telling me that he's having difficulty, but not once has he filed a motion to withdraw or called and complained about you. It's only been you about him.
Yes, sir. He brought my mother into the situation, sir, and she's been dead for 32 years. He said, I've been down here acting an animal and talking crazy to everyone that has my freedom in my hand. I didn't have no problem since I've been here at the jail, period. And he said, that's going against my manhood as being a father and a husband, provider for my family, saying that I want to take care of the responsibilities of the guy that is the co-defendant. He owned property. I don't own any houses. And that's why I said if I could get that bond reduction, and for my lawyer, he would speak up and say, hey, this is a good guy. And regardless if I don't have any ties here in Vance County, I was at home when I was picked up. And that's the case that I was trying to make about him being my attorney, or is trying to get me back to my family, and I can come to court and we can do this just like now. I can talk to him on the phone or come to his office while I'm outside of this place. That's the only thing I was saying about the apartment. My co-defendants own houses, and that's what we come down here to do. But this case is probably a year off, and I just felt like that, after 9 months. If everything's incomplete, why should I have to sit here when I can be there providing and just trying to get on with my life also?
Well, I haven't heard any evidence that something is incomplete. The state has filed an indictment and they made offers to you. And so the case is going forward to trial. So there's nothing incomplete that, to my knowledge. Mr. Ashmore, is there anything that's incomplete? Have you been provided with discovery in this case?
Judge, I have. I've only been appointed to Mr. Hobson since March 1st or 2nd. And since then, we've had multiple very abrasive communications in the jail. There seems to be zero lack of reality or understanding by Mr. Hobson about the nature of the allegations against him. And, whether that's consistent with, something that whether that's consistent with something in his cognitive ability or not. But the bottom line is this young man does not like the reality of the situation that he's in. He seems to also want me to be here waiving attorney-client privilege, telling the court what my opinion is about the case, which I have a severe problem with any client trying to make his attorney do that kind of waiver in court. And I don't think that, that's something for the locker room, not out here on the field. Mr. Hobson seems to have zero cognitive comprehension about the difficulty and the challenge that he faces being an out-of-state defendant with no property. Before I heard today's testimony, one cousin in the state who lives in the city of Dallas, who he doesn't know the name and number of. I never referred to his mother. I did refer to his wife, who did get emailed the paperwork that would be required to assist the court in some sort of bond analysis. That paperwork was never filled out right. And, that's kind of telling that there's just no information to give the court, because it's been explained as best we can, given the long distance. And, I understand Mr. Hobson's frustrated that he's not free, but that didn't have anything to do with my appointment. Moreover, since March 1, I've explained to him over and over and over again, he doesn't meet the qualifications for an in-state PR bond or a bond reduction for an out-of-state defendant with no significant contact with the state of Texas. And that's statutory. I've explained to him that's not a judge call. That's not a Casey Ashmore call. That is a Texas legislature call. And that's just not information that he likes to hear or understand.
Let me ask you this, Mr. Ashmore. Do you believe that you can still effectively represent Mr. Hobson? Do you believe that there's still an attorney-client relationship there? Or do you believe that has deteriorated to the point to where he's not going to listen to your advice, or you're not going to be able to communicate with him? And before you answer that, let me ask you, do you believe that if I appoint another attorney, that it's going to be any different with the next person? You're on mute, Mr. Ashmore.
Sorry, Judge. I'm not shirking any duty, but I don't believe it would be any different. And, if I know Mr. Hobson thinks that if he makes enough noise, he will get his way with the issue of his personal freedom. Who wouldn't want to be free? It's COVID. His family's a long way away, and he's in jail in Van Zandt County, Texas. I get it. I totally get it. I don't think that the disruptive behavior from his family, from him, will stop if you appoint one of our colleagues on the case.
So address for me your relationship with Mr. Hobson and whether you believe that you can still effectively represent him.
But I'm not asking the court to terminate the relationship. I know Mr. Hobson is, so I'll just leave that in the court's capable hands. Thank you, Your Honor.
All right. So, Mr. Hobson, the court's going to deny your request to have Mr. Ashmore removed as your attorney, and the court's going to deny any request for a motion to reduce bond. Your bond remains set at $100,000.
Okay. Well, it's still in the system. It's 200,000. It hasn't been updated If you look me up, it hasn't been updated in the system as, it's still saying 200,000.
I'm not sure what system you're referring to, but
But when they look up of my bond, when I talked to the bondman, they said it was still on 200,000.
well, I can just show you what I'm referring to is, here's what the system shows. This is you. This is the bond. So if it's showing,
Yeah.
Mr. Ashmore, I'd ask that you look into that state. I'd ask you.
Yeah, no, Judge, this is the result of that first hearing that we had on the bond issue. And at that first hearing,
We've lost you, Mr. Ashmore.
sorry, Judge, I'm going to switch back to my notes. At that first hearing, Your Honor, was presented a request by Mr. Hobson regarding, that was around April 5th or the 14th, something like that, that there would be a request from the defendant, and the court actually partially entertained that. There was a question about the 3 charges and was the bond good, et cetera, and the court confirmed a $100,000 bond, and that's my understanding of what it's been since mid-April.
Mr. Woodwise is going to say something, but he's going to move closer to the bench so we can be sure to hear him.
Judge, it does appear as though on the man delivery, I believe it's a conspiracy charge, the bond is $100,000. However, there is also an unindicted money laundering case, which likely has a $100,000 bond as well, which I do believe is unindicted, and he has been in jail for a substantial period of time. I don't know if that has ever been handled, discussed. Again, I'm not handling specifically this case, but I'm just, based on my review, the bond in this case is $100,000. He likely has another case that has $100,000 as well. I don't know if that has, since February, if that has ever been handled, if that has ever been discussed. I don't know. It appears from the sheriff's office side that there is a $100,000 bond on each case.
All right,
So that may be some of the confusion.
So Mr. Ashmore, if you've been discussing it with Ms. Curry, I'm going to ask that the two of you look into it and see if that is what is causing Mr. Hobson to believe that there's a $200,000 bill. If it's $100,000 for each case, one for the indicted case and one for the unindicted case. And if he's not been indicted on the money,
I will,
as Mr. Woodwike says, then the court would grant him a personal bond in that case if he's not been indicted, but the court's going to maintain $100,000 on this indicted case.
Thank you.
yeah, Judge, can I speak 1 second to that, Your Honor?
Yes.
If I understand right, if he gets a PR bond, he loses any time credit. He can't make bond on the second 100. And we've told him that. We've told him that over and over and over.
If
he gets a
Mr.
PR
Hobson,
bond.
yeah, and let me say
I'm
this,
sorry.
if Mr. Hobson, it's okay, if Mr. Hobson gets a PR bond on the money laundering charge that is currently unindicted, if it is later indicted and he is later convicted of it and later sentenced to any amount of time in the penitentiary on that charge, he would lose any credit from when he's sitting in jail on a PR bond. So if that were granted today, he would get any credit that he was due prior to the granting of a PR bond.
Right on. Yes, Judge. I understand that. Thank you.
And I believe that's what you were saying. So I was just saying that for the benefit of Mr. Hobson. So, but if Mr. Hobson wants to on that and is aware that his credit stops, then the court will grant that at his request. So gentlemen, this is what I'm going to do. I'm going to set this for another docket call hearing on September. Are you available on September 28th, Mr. Ashmore? I can't remember where I've set you before in other.
I think I'm on that docket already.
All right. So on September 28th, Mr. Hobson, we're going to come back, and what I'm going to want to hear from you on the 28th is whether you're going to accept a plea agreement or if you're going to ask for a bench trial or a jury trial. Okay? And in the meantime, we'll get the decision on your money laundering case. And, okay?
Is there?
All right, we'll see you on the 28th.
All right, thank you.
Mr. Hobson.
Mr. Stevens, are you there in the jail and are you ready?
Yes, sir, I am.
All right, we'll get you next, and then I'm gonna get you back over here.
Yes, sir.
Judge, is that everybody today, or is Mr. Davis set today, Your Honor?
And Judge Martin,
Yes.
I'm
I'm
sorry,
sorry.
we don't have Mr. Stevens' clients up here. We can get him up here, but it'll take a couple of minutes. Do you want to go with him or Mr. Sanders?
Well, if Mr. Sanders is ready to go, let's go ahead and knock him out. I do want to get Mr. Stevens in line so we can get Mr. Rice handled so our witness can.
Yes, sir.
And so, Mr. Ashmore, with regards to, who did you say, Davis?
I'm sorry, I meant Banks. I'm sorry, I meant Banks, Your Honor. Is Banks on the docket? I thought he was.
Yes, we pled him out earlier
Can we bring it up to the court?
with Carlo D'Angelo.
Oh, perfect.
Were you aware that he had subbed in?
I was not.
They were very complimentary of you. Anyway, they pled, Mr. Banks pled to some time served, I believe. Is that correct? I can't recall exactly. Yeah, so he did a 60-day, 1244A, I believe, or something like that.
Sorry, Judge. Sorry for the confusion. Maybe I did know that and I forgot.
Sorry,
Forgive me.
no problem.
We emailed about this, you, me and Mr. D'Angelo, who filed a motion for substitution that wasn't ever, I don't think there was ever an order signed, but we all just agreed that was happening and agreed that I could negotiate with him.
Yeah. Thank you.
So get,
All right,
get-
Judge Meg.
yes, yeah, get your bill submitted on that and you're free to go.
Okay, thanks, Judge. Have a great day.
You as well. Mr. Sanders,
Yes, Your Honor.
I'm ready for you.
Got Mr. Amador, Daniel Amador.
Please come up, Mr. Amador, CR 21-204-205. Set for pretrial hearing. Go ahead, Mr. Sanders.
And Judge, we don't have any pretrial issues and we just ask for it to be set for a docket call.
All right, court will set Mr. Amador for docket call on September 28th. That'll be at 1:30 if he's in jail, 9 a.m. if he's in bail. And Mr. Sanders, just make sure your client is aware that I'm going to expect some kind of announcement on the 28th as to whether he wants to take a plea agreement or he wants to go to trial. And if he goes to trial, the court will not accept a plea agreement after the 28th, other than an open plea. All right, what about Mr. Vance?
Yes, we're ready on him too.
Mr. Vance, if you'll come forward, CR 2140, also set for pretrial.
Judge, and we filed a motion to suppress, so we asked for a evidentiary hearing on his case.
Okay. We'll set that September 30th. And that'll be at 1:30 since he's in custody.
And Judge, I believe that's all I have.
Thank you, Your Honor.
Thank you, Mr. Sanders. You're welcome, Mr. Vance. Mr. Sanders. All right, that should leave Mr. Stevens with Mr. Heredia and Mr. Williams. Should both be pleased.
They've gone get my clients now, Judge.
Thank you, Mr. Stevens. And then Mr. Adams is probably nearby.
Understanding was I was willing to because I was there when he got available from the other jurisdiction. And then that may change, but you know, we took the paperwork out to the bill.
Okay. That's probably right. I probably just forgot about that.
He will either be here or on Zoom.
Okay.
These are your clients, right?
Yes, sir. Yes, ma'am. And I'll call your wife this evening when I get back.
We're ready when you are, Mr. Stevens.
I'm ready, Your Honor, for whichever case you want to call.
Call Oscar Heredia, CR 14220. All right, are we pleading Mr. Heredia today?
Yes, sir.
All right, and I don't have any paperwork here, so can you give me the rundown of what we're doing?
Yes, sir, I will. He stands charged with a second-degree felony, and the original sentence was 10 years TDC, probated for 5 years with a $2,000 fine. Today, he plans to plead true to all of the allegations in the state's motion to revoke, and he has the sentence will be, Your Honor, for 4 years TDC. He has 213 days back time credit, fine of $2,000, court cost of $885.19, and it appears 0 reimbursement fees.
Any other cases being resolved at the same time?
No, Your Honor, this is the only one.
All right, Mr. Heredia, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you may put your hand down. Give me just a second here. Let me pull up your case. All right, Mr. Heredia, you appeared before the court on August 15th of 2019. You pled guilty to the second-degree felony offense of possession of a controlled substance in penalty group 2, greater than or equal to 4 grams, but less than 400 grams. Court heard the evidence, found that there was sufficient evidence to convict you of that offense. The court did convict you of that offense, assessed your punishment at 10 years confinement in the Texas Department of Criminal Justice, ordered you to pay a $2,000 fine, and the court then suspended that sentence and placed you on community supervision for a period of 5 years. It was during the terms and conditions, is during the term of your community supervision that the state filed a motion to revoke, alleging that you violated your terms and conditions of community supervision. And upon filing that motion, they have alleged that you violated in 6 separate counts. Have you had an opportunity to review that motion with your attorney, Mr. Stevens?
Yes, sir.
Feel like you have had enough time to discuss the case with him, have all your questions answered?
Yes, Your Honor.
Are you pleased with his representation of you?
Yes, sir.
And do you believe him to be competent, Mr. Stevens?
Yes, I do, Your Honor.
All right. Court finds that Mr. Heredia has waived the formal reading of the state's motion to revoke. So at this time, I'm going to ask you, let me share the screen with you, make it easier for you. This time, I'm going to ask you, Mr. Heredia, how do you plead to counts 1, 2, 3, 5, and 6? Are those counts true or not true, sir?
True, sir.
And Mr. Heredia, has anybody threatened you, forced you, or pressured you to plead true to these counts today?
No, sir.
All right, the court will accept the defendant's plea of true to each count as alleged. Mr. Stevens, any objection to the admission of the defendant's waiver of rights and plea of true as State's Exhibit A?
No objection.
State's Exhibit A is admitted in evidence, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we would rest in peace.
Anything further, Mr. Stevens?
No, Your Honor, rest and close and just ask the court to follow the plea bargain agreement.
All right, then based on the evidence before the court will find that Mr. Heredia has violated his community supervision. Court will follow the plea agreement in this case. Court hereby revokes Mr. Heredia's community supervision, assesses his punishment on the second-degree felony offense of possession of a controlled substance in penalty group 2, greater than or equal to 4 grams, but less than 400 grams, at 4 years confinement in the Texas Department of Criminal Justice. Institutional Division will order him to pay the balance of his financial obligations, and the court will award him 213 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Heredia, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Good luck to you. I'm going to have you step over with the deputy to be fingerprinted.
Thank you.
You're welcome. Who are you ready for next, Mr. Stevens? Mr. Williams?
Mr. Williams, Your Honor.
Mr. Williams, if you'll come on up. Okay, Ms. Heisel said she's going to give me the terms of this plea. Go ahead, Ms. Heisel.
Your Honor, this is a DWI third or more with one enhancement paragraph, making it a second-degree felony. Your Honor, the state is recommending upon a plea of guilty, punishment be assessed at 20 years in the Texas Department of Criminal Justice Institutional Division, a fine of $2,500, including that $2,500 includes the $100 EMS trauma fee, $60 restitution. State has also agreed to 1245 CR 2146, which is an unlawful possession of a firearm by felon, and unindicted DA 2020-0354, which is a possession of a controlled substance, 4 to 200 grams. State is there's $70 reimbursement, $290 court costs. State is giving Mr. 482 days back time credit towards this plea.
Did you hear Ms. Heisel, Mr. Stevens?
Yes, sir.
Is that your understanding of the plea agreement?
Yes, sir, it is.
All right, Mr. Williams, if you'll raise your right hand, sir. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you may put your hand down. You are John Charles Williams, is that right?
Yes, sir.
Mr. Williams, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
And in this case, you're represented by your attorney, Mr. Bill Stevens. Are you pleased with his representation of you?
Yes, sir.
I feel like you've had enough time to go over your case with him and have all your legal questions answered.
Yes, sir. I have.
Is there anything in this paperwork that you've read and signed that you do not understand? And is that your true and correct signature on those papers?
Yes, sir, it is.
Okay, and you understand everything?
Yes, sir.
And Mr. Stevens, do you believe him to be competent today?
Yes, sir, I do.
And I don't know if I've asked you, Mr. Williams, are you pleased with Mr. Stevens' representation of you?
Yes, sir, I am.
Okay, so you heard the plea agreement, Mr. Williams. You are charged by indictment with a third-degree felony offense of driving while intoxicated, third or more, and the state has alleged an enhancement paragraph, which, if proven to be true, would enhance your range of punishment to that of a second-degree felony, which carries a range of punishment of not less than 2 years or more than 20 years confinement in TDC and a fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, sir.
Okay, and I would find that the plea agreement as proposed would fit legally within the range of punishment. So to the charge of driving while intoxicated, third or more, how do you plead? Guilty or not guilty?
Guilty.
And to the enhancement paragraph alleged in the indictment, is it in the indictment, Ms. Heisler?
Your Honor, yes,
Okay.
it's actually indicted as a habitual felony offender, 25 to life. We are abandoning one of those enhancements to make it fit within the 2 to 20 range.
Do you know which one you're abandoning, the first one or the second one?
It's the second one, Your Honor.
So, Mr. Williams, how do you plead to the enhancement paragraph, the first enhancement paragraph in the indictment concerning your prior conviction? Is that first enhancement paragraph true or not true?
True.
Okay. And Mr. Williams, are you pleading guilty and true in this case because you are guilty of committing that offense and because that prior conviction is true and for no other reason?
Yes, sir.
And has anyone threatened or forced or pressured you to plead true or plead guilty today?
No, sir.
All right, Mr. Williams, court will accept your plea of guilt. Mr. Stevens, any objection to states one?
No objection.
States one's admitted in evidence, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor, I'd just like to draw your attention to one matter. On the second page of the judgment, there is a disposition regarding a firearm in the unlawful possession of a firearm by felon case that is being 1245. Mr. Williams' wife, as well as her brother, both contacted our office to let us know that is a family heirloom. Mr. Stevens, on behalf of Mr. Williams, requested that be returned to the wife and her family in accordance with this plea agreement. And because of Mr. Williams's significant sentence, we are confident that that is not going to go back into his hands. And we have put in a judgment for that firearm to be released back to her for their family.
Okay. Mr. Stevens, anything further from the defense?
No, Your Honor, witness.
All right, and Ms. Heisel, if you'll give me a summary of the facts.
Yes, Your Honor, as to the DWI on April 14th of 2019, a DPS trooper observed SUV driving with a defective headlight, executed a traffic stop on that vehicle, which was driven by Mr. Williams. He was asked to step out of the vehicle. As he was doing that, the trooper realized that he was unsteady on his feet. He could smell alcoholic beverage. He had bloodshot, watery eyes and slurred speech. Mr. Williams admitted to consuming multiple beers that evening and admitted that he did not think he should be driving at the level of intoxication he was at. He started standardized field sobriety, did not complete that, was placed under arrest and asked to consent to a specimen. He refused. DPS office came and got a warrant from this court for a blood draw They did conduct a blood draw and the specimen returned at 0.24 grams of alcohol, BAC on Mr. Williams.
Mr. Stevens, any objection to that summary?
No, Your Honor.
All right, then based on the evidence presented to the court will follow the plea agreement. In this case, the court hereby convicts John Charles Williams of driving while intoxicated, third or more offense, a second-degree felony based on enhancement. Court assesses his punishment pursuant to the plea agreement at 20 years confinement in the Texas Department of Criminal Justice Institutional Division, orders him to pay a $2,500 fine, $290 court costs, $70 in reimbursement fees, $60 in restitution. The court takes into consideration under section 1245 of the Texas Penal Code, cause number CR 2146 and DA 2020-354, possession of controlled substance. Court will find that the weapon seized in CR 2146 has been agreed to be returned to the family members of Mr. Williams in accordance with the seizing agency's policy on return of weapons. Court awards Mr. Williams 482 days credit towards his sentence in this cause for time previously served. Mr. Williams, I'm going to have you go with the bailiff to be fingerprinted. Good luck to you, sir.
Thank you, sir.
You're welcome.
Judge, I'll be along in just a couple of minutes.
Thank you, Mr. Stevens. I appreciate you.
Yes, sir.
You got another set of.
I do. Thought about that.
What will it take it for?
I knew you would.
Your Honor,
Yes, ma'am.
I do have Mitch Adams as client in the room as well.
Okay, I haven't seen Mr. Adams yet. I think he is still trying to get back from Smith County, I believe is where he's at. So as soon as he gets back, I'll let you know. Mr. Stevens is on his way back over. So we're going to go ahead and start Mr. Rice's hearing, and then we'll wrap up with Mr. Adams.
Okay, thank you, sir.
So feel free to mute and turn your camera off.
I sure will. Thank you.
Thank you.
All right. All go with my there.
You want me to take those back?
No cooking with fire. There we go. And so there I am. Now, I'm trying to get Mitch to come back to us. There he is. There he is. All I'm saying is hello.
Oh, hey.
Hang on, Mitch. She doesn't want to hear us say hello. She's still working from the pilot's cockpit to rig us up so that we can say hello confidentially.
All right.
It did not yet. Mitch, do you have an invitation to a breakout room? Oh, there it is.
Yeah.
Okay, I've got mine. I'm joining and we'll let you and your guys talk.
All right, this is cause number CR 2407, State of Texas versus Abram Hastings Rice III. I believe that we are set today on the state's motion to adjudicate and revoke community supervision. Mr. Stevens and Ms. Heisel, what has been the offer to resolve the case for Mr. Rice?
Your Honor, the state offered 15-year CDC. The defense counter offered, the state re-offered 12. My understanding is both of those have been rejected by Mr. Rice.
That is correct.
Okay. All right, we ready to proceed on the motion?
Judge, before we get started, if I may, I had a witness I'm going to want to call by telephone. It's his mom. She's like 84 years old, I believe. She's unable to get to the courthouse, so I respectfully ask that we would be able to get her on the phone as a witness for my client.
All right, how come she wasn't already arranged to be here in person?
Judge, she has had COVID. She's very weak. She walks on a walker. She has nurses that come out twice a week, and she physically was not going to be able to be here. I did have her daughter was going to try to bring her, but they just couldn't bring her. She's just too feeble to be able to come.
And can she access the court via Zoom?
No, Your Honor, she does not have the technological ability. And so, however, her daughter was in town yesterday, but left early this morning. We could get the daughter back and she would be able to, through the cell phone, get her mom on Zoom.
All right, due to the timing of the request, the court's going to deny the request to allow any witness to appear via phone, wherein the court could not ascertain the true identity of that individual or the confidentiality of their testimony or being coached or anything of that nature. So the court's going to deny the request to appear by telephone. Court would grant the request to appear via Zoom, but it's my understanding there is no technological capability of her to do that. And so the court's going to deny any request to continue the hearing for the purposes of a witness to appear via Zoom.
That was going to be my next request. Your Honor, was a verbal motion for continuance to be able to get Ms. Rice set up via Zoom.
Okay. And I noticed that Mr. Rice has the microphone on. I think I instructed to have the witness wear the microphone. So this lapel mic that's on Mr. Rice should be on the witness. So I don't know who put that on, but we need to move that microphone off of the defendant and we'll move it on to the witness. Anything further, Mr. Stevens?
No, I'll misunderstood. Did you grant or deny my motion for continuance?
I've denied the motion for continuance for the purposes of trying to allow the witness to appear via Zoom. We could have, I believe that Mr. Rice should have had that already arranged if that was his intent and should have made that request prior to today.
Yes, sir.
I can't hear you.
Yes. Yeah.
All right, is the and it doesn't have to be right there on him. When he gets ready to testify, he's going to come up here anyway. So
Is he going to be on the witness stand?
he is. So he doesn't need that in front of you.
Yes.
You can have it on the table. Is the state ready to proceed on this motion?
Yes.
All right, go ahead, Ms. Heisel.
The state would waive opening statements and call to the stand Deputy Travis Spurgeon.
All right, Deputy Spurgeon, if you'll come forward, please. Deputy, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, please have a seat. Just make sure you speak up loudly and clearly. My court reporter here to your left is going to take down everything we say in court today.
Yes, sir.
Go ahead, Ms. Heisel.
Thank you, Your Honor. Deputy Clerk, would you please spell your name into the record?
Travis, Travis, Basil, Spurgeon, Spurge.
And I see you here in a sheriff's department uniform, that means include the name of my sheriff's department.
Yes, ma'am.
And does that mean you're a licensed police officer in the state of Texas?
Yes, ma'am.
And how long have you been a licensed police officer?
Approximately 9 years.
And are you current with all of your continuing education to keep your license current?
Yes, ma'am.
What is your current position held with the sheriff's office?
Deputy 2.
And what are some of your job duties with that?
Patrol the county, take calls, force laws for the state.
When you say take calls, do you respond to dispatches from 911 calls? And on March the 30th of this year, did you respond to a call out at an address in Edgewood off of 859? If I told you the address of 1282 at 859 Edgewood, does that sound familiar to you? Sure. Yeah, if you want to make sure. To your knowledge, who resides at that property?
Lewis Rice.
You say sons, how many sons does she have? And you both of them reside at that property as well? And actually, on that evening of March the 30th, were you called out to that residence on multiple occasions? How many times that evening did you call her?
Sure. I believe it was 4.
But multiple, is that correct? And were was the nature of the call the same every time?
I do not
Okay. Were any of the nature of the calls in regards to a disturbance?
do not
But you had a reason to go out there, correct? And what was that?
The last one,
Any of the times that evening?
the last one was a disturbance, involving Mr. Rice and Ms. Lowe's. They got into an argument, and she stated that he was ready to charge.
And was that information communicated to 911 dispatcher?
I believe it was.
Was that information also communicated to you once you arrived on the scene? You went out there multiple times that night. The first time you went out there, was that the allegation? At the first interaction you had with Ms. Lois Rice that evening?
I don't know.
But at some point, she called 911 and reported that threats had been made to her life. Is that correct? When you arrived at that address, did you locate this? And earlier when you, sorry, back up just a second. Earlier when you indicated Mr. Rice, you kind of pointed over here. Do you see Mr. Abram Rice here in the courtroom today?
Yes, ma'am.
And can you identify where he's sitting?
He said, next.
Thank you, Your Honor. I would ask for the court identification of the defendant to be reflected in the record.
Court will so have the record reflect that this witness has identified the defendant, Mr. Abram Rice III.
Thank you, Your Honor. So, Mr. Spurgeon, when you went out to that property, you encountered this man, Mr. Abram Rice. Is that correct?
Yes, ma'am.
And when you took the statement from Ms. Lois Rice, did you take a oral statement from her?
The first time I took the oral statement, we had a written statement, which I wrote on her behalf.
And you're gonna have to speak up. I'm having a very hard time hearing.
So the first time that we went out there, or first time I got the statement was a verbal statement. We did get her to give a written statement, but the written statement I had to write on her behalf because she don't put anything right, is what she told me.
Okay, so you wrote that statement after dictation and at her request, is that correct?
Yes, ma'am.
And then did she sign that statement that you wrote after she reviewed it?
Yes, ma'am.
And based on what she had told you verbally and also what was contained in the written statement, did you believe that there was reason to believe that a crime had been committed that evening?
Yes, ma'am.
And at that point, did you place Mr. Abram under arrest?
Yes, ma'am.
What was the offense for which you placed him under arrest?
Terrorist is very illicit.
And when you attempted to place him in restraints, to place him under arrest, what happened at that?
He pulled away from me and Sergeant Gonzalez. Initially, we ran him in custody. Then we took him out to my patrol vehicle, at which time he refused to get the patrol vehicle.
And at that point, did you add an additional charge of resisting arrest or transport to
Yes,
Mr.
ma'am.
Rice? And then at that point, Deputy Spurgeon, did you transport him to Vance County Jail?
Yes, ma'am.
Did you book him into custody at that point?
Yes, ma'am.
And did that include your interactions that evening with Mr. Rice?
Yes.
All right, pass it.
Mr. Stevens?
Thank you. Deputy, I feel Stevens will ask some questions. Was, once Mr. Rice was in the car, being taken off to jail, was he on injured at that time? Was he still resisting?
I do not remember.
Okay. Would you have ready to report if he had been on injured and resisting after jail?
Most likely.
Did Mr. Rice fight you guys?
He passively resisted by pulling away from us. He didn't fight us by throwing punches.
So he didn't strike you or attempt to strike you or any of the deputies, is that correct?
No, he had put a different charge on.
Okay, and basically, I think you testified you gone out there a few times prior to that, is that fair statement?
Yes.
Okay. Why was Mr. Rice not arrested the prior times he went out?
Because his mother Lois, we tried to get a statement from her at that point, and she was uncooperative and refused to write a statement and refused to dictate a statement to be written by one of us.
Was anybody besides the deputies and Mr. Rice and his mom, was anyone else there at the location?
I don't remember.
Okay. Do you recall you or any of the other deputies that were there telling Mr. Rice he better leave the property, leave the residence? Do you recall having that conversation?
I remember the first time we were out there, when she was pretty much cooperative with writing a statement. Mr. Abram agreed to go to another building on the property. That was on the campus. So, and he said that that's where he would remain.
And when you came out to make the arrest, did Abram explain to you that he came back to the house because it was storming and the cabin he was going to was locked and he couldn't get in?
I don't remember what he told me was the reason why he came back to the house.
Okay. Do you recall whether or not the Mrs. Rice called the police out because she heard someone trying to get in the back door of the house?
I don't recall.
Okay. Mr. Abram Rice lived at that residence, is that correct?
As far as you know, he's lived there for quite some time.
Not sure how long it's in there.
As far as you know, though, it's correct.
Yeah, that's where.
Okay. Thanks, Charlie.
State any additional questions?
No, Your Honor, we asked this would just be able to be exposed.
All right. You're excused. Thanks, sir. Yeah, if you'll just take that microphone off. Otherwise, we'll hear you all the way to the car. Catch you, Solo. Ms. Hazel, any additional witnesses or evidence?
Yes, Your Honor, the state called here.
Ms. Burns, if you'll come to the stand. Raise your right hand. Ma'am, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? Please have a seat. You may proceed.
Thank you, Your Honor. Ms. Burns, would you say your name for the record? Karen Burns. And how are you currently? I'm employed with the Vance County. And what is your title on here, the director? Do you have knowledge of Abram Rice? Yes. Do you know him as someone who was placed on supervision? Yes. Do you know what day he was placed on supervision in your department? Yes, it was January 26, 2021. And do you know which of your officers Mr. Rice was reporting to? Jarvis Crawford. Do you know how many times Mr. Rice reported to Mr. Crawford? Reported every month. And was the Vance County Department of Community Supervision notified sometime in March or early April that Mr. Rice had committed new offenses in the state of Texas? Yes. How many new offenses? 2. And were those committed here in Vance County? Yes. And is that a violation of his terms of community supervision? Yes. In fact, that condition A, community supervision? Yes. And so at that point, I believe it was April 15th of this year, your department received a motion to adjudicate filed. Yes. Other than the 2 new alleged violations in the motion to revoke, were there any other violations by Mr. Rice of the terms of his community supervision that were not alleged in the motion to adjudicate? No. Was he current on all of his payments? I believe so. Might have been a couple months later. So if the state shows that he was $130 delinquent on payments, would that be consistent with your understanding? Yes. And what is your department's policy on being behind or delinquent on supervision payments in terms of putting that in the state motion to adjudicate? 3 months or more. Okay. So Mr. Rice was placed on deferred community supervision in January 26th of this year. And he committed a new offense in March of this year. Basically, he would have had time to arise to that violation. Is that correct? But in that time, he did rack up 2 charges as far as you're aware. Yes. Do Do you know, Ms. Burns, what the term of this community supervision was? I believe 5 years. And do you know what kind of charge that was for? Your Honor,
Mr. Stevens?
Thank you. So Ms. Burns, the only allegations that you really alleged were the 2 new offenses, correct?
I did not allege them because Officer Jarvis Crawford did. I'm just keeper of the records, but yes,
Okay.
those are the only 2.
Okay. It means that you allege. Okay. That's the only 2 violations.
Yes.
Okay. And as far as you know, he did report as he was directed, correct?
That is correct.
Okay. No further questions.
Anything additional from Ms. Burns?
no, Your Honor, and I'd ask that she be perfectly excused.
All right, you're excused. Any additional witnesses or evidence?
No, Your Honor, state the rest.
Mr. Stevens?
Like to call my client, Your Honor.
Mr. Rice? Come up here and have a seat in the witness stand. Mr. Rice, I'm going to place you under oath best you can. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God? Yes, sir. All right, maybe put your hand down before you sit down. Do you understand that you have a Fifth Amendment right to prevent you from being compelled to testify and give evidence against yourself? Do you understand that? And so that's your decision to make. It's not your attorney's decision or my decision or anyone else's. And so are you making the decision today to take the stand and give testimony?
Yes, sir.
All right, please have a seat. Go ahead, Mr. Stevens.
Thank you. Please state your name for the record. Abram, the judge basically admonished you that you did not have to testify. You and I had that conversation many a times, have you not? Yes. Okay. I told you under no circumstances did you have to get up and testify. You understand that, right? Yes, sir. Okay. Now, you pled not true to these allegations in the state's motion. You're alleging they're not true. Right. Right. You're alleging that one of the violations is that you threatened your mom, Lois, terroristic threat, basically, or you denied that allegation. Yes. Right. And you heard the officer testify a while ago when they came to arrest you that according to their summation that you resisted. You understand that? Yes. Okay. And you're saying that you did not resist.
I was innocent of the charge.
Okay, wait.
No,
Did you resist the officers?
No.
Did you strike, assault, cuss, abuse the officers in any way? Okay. You heard Deputy Spurgeon testify that they were to arrest you, that you kind of pulled away and were cooperative. Was that a fair statement by what he said?
Yes.
Okay. Why did you do that? Okay, innocent of the charges of terroristic threat?
I never said about that.
Okay.
I never had one. It's the only thing I've got.
Did you tell the officer when he was trying to arrest? What did you tell the officer? You made a statement to me. You made me finish. You made a statement to me. Okay. Tell the court what you told the officer at the time that they were trying to place you in custody.
That I didn't commit this crime.
Did the officer?
I didn't need to go to jail. I had to go to probation.
Okay. So you acknowledged you were on probation at that time.
Yeah.
Right. And you knew you had to report to probation. I mean, that's on your list of things that you told the officer.
Yes. Very much true.
And you reported as directed?
Yes.
You heard a little testimony that you might have been a little bit behind on money. Is that an amount that you're made up easily?
Yes, sir. Okay. I just got out of jail and I had the money that
Okay.
hey, I was gonna make a payment on I think it was supposed to be the 6th of April. That I was supposed to report. I was gonna make the money up then, but I got locked up on the 31st.
Okay. Yeah. The officers came out and told you to basically find a place to go?
Yes.
Okay. What did you do?
I told him that I would go down to my uncle's cabin.
Okay. Did you go down to your uncle's cabin?
I went down there, well, first, about halfway, I come back to the house and knocked on my mom's door. I mean, her front door. And I asked her, give me my cigarettes. Well, she had a partner. She got scared when we knocked on the door. She didn't know who I was. So I just left Dad, got on my lawnmower, and I drove down to the cabin. I got to the cabin, and the cabin was locked. So I come back up. So I had a little camp down there where I was set. And I was back in there out north. There was thunder and lightning and everything else coming my way. And I couldn't sit up there all night. Okay.
So how did you get back into the house?
So I went back to the house and I get the back door, the doorknob, and it opened up. And I went in and I laid down in bed with my dog. And I guess it was 10 or 15 minutes. Police come in and told me
When you went back into the house through the back door?
Yes.
You lived there, right?
Yes, okay.
That's your home.
2003.
Okay. When you went into the back door, did you go and see your mother at that time, or threaten her, or make any comments
no,
or
I-
statements to her?
No, it was getting late. And I didn't want to go in there and start her.
You
I mean, I
didn't,
knew she was already upset.
did you even see her when you went
I
back?
didn't see her. I didn't see her.
Why did you go back to the house?
I just went back to lay down. Go to sleep. They had no other place to go.
And when the police showed up, tell me what happened.
Well, I told them I know about it. And I said, oh, it's gonna storm out there. I had no cabin with lock. And, you know, I had to go lay down. This is my house. And I had nothing wrong.
Did you have any place to go to get out of the bad weather other than your house?
I mean, I got a cousin who's next door, but he's always in trouble doing that. No, I didn't have any place to go.
Okay. You're an ex-Marine, is that correct?
Yes.
And you're on disability.
Yes.
What's your disability?
I broke my neck twice in a car wreck. In 2003, I broke it the second time. And I had to quit my job in Fort Worth, and I moved down with my mother, take care of the place, take care of her, and put me on SSI.
Okay, so what's your income?
That's around $1,100.
Do you have any other income besides your SSI?
No, that's all I got.
You get any pension or anything for the Marines?
No.
Okay. You're going to ask the judge to continue your probation, aren't you?
Yes.
Does your mom have a deed for you to go back and go take care of her?
Yeah, she's the only one there. My sister, she lives in Fort Worth. She has to take care of her family. She's got 2 twin daughters and a son. And 2 twin daughters have their family. And I mean, she's got to take care of her Fort Worth. She can't keep running back and forth down here.
What do you actually do to help?
Oh, I feed her. I do all the yard work. Matter of fact, the yard work right now, my brother's a dope addict. He's been living there since he got out of prison. For the last 3 years, I've been trying to eradicate the prison. That lifestyle there, him doing dope there at the house and bringing over a bunch of people that want to steal all our stuff. He even stole my mom's pistol out of her room when I was in jail. And my mom's all I got. I don't have kids. I don't have a wife. All I got is my mom and dog.
You've never been to prison, have you?
I've never been to prison.
How old are you?
I'm 62.
62.
in October.
If the judge were to decide to continue your probation, not send you to TDC, is there any assurances, can you make the judge any assurances that he won't see you back here again?
Yes, sir.
What kind of assurances can you tell me?
Well, I'm gonna make all my payments up. Everything. I've been working on trying to get my t-shirt done. I draw content drag race. And I really got some fast from. Now I'm at the point that I've got it up. That I'm gonna get my copyright's done. And I choose to get a company out there to buy to sell my t-shirt for. And it's been a dream of mine for a long time. But I've got to the point that now I can do that. My mom is so happy for me. She's all I've got. I learned since I was in this. She fell. She got dizzy when she stood up. I didn't even know she had one. See, she got dizzy when she stood up and she fell back and hit the grandpa on the clock and broke 2 ribs, punctured the lung, and no one was there to help her. And my brother was, but he's screwed up on dope all the time. He don't know what he's doing. My mom needs him. She really needs him. Notion of this world is this world. Like I said, I'm taking care of it.
Are you asking the judge to continue your probation?
Yes, sir, I am asking.
I'm fixing to pass you to the state. And I told you when we visited the jail many a times, they're gonna be asking you questions, okay? Before I do that, is there anything you want to tell the court that maybe I failed to ask you, or that you think the judge should know?
I just think I need to get another chance at probation. I've really tried hard. I've tried to keep these drug addicts and drug dealers away from my house. My mom, she's in such bad shape, she really doesn't even realize that my brother was doing all that. And they went in there and stole all of my tools, my knife collection, all a bunch of stuff. The only thing that I said, we didn't talk to my mom about, was I working with my mom, I didn't have enough tools because they stole all the tools. And in there, and I saw, I was at work with my mom, and we were talking. And I got into the wood about how they stole all my stuff. And that I couldn't really work on the lawnmower, I can't do this, Mark's always on dope. All these dope dealers keep coming by, I can't get, and I can't get rid of it. I'll try. Because he keeps bringing them back. But the only thing I said, but I should have called the law. And then I said, I walked out the door, as I walked out the door, I said, no, I should kill him. I was talking about the drugs and shit. Excuse me. I wasn't talking about my mom. My mother.
Were you just frustrated and made that comment out of frustration?
Yeah, I was upset, yeah. But I didn't say anything for my mother at all.
Would you ever purposely harm your mother?
No, I never purposely harmed my mother. My brother wouldn't even beat her.
If you're out there, are you able to cook for her and do grocery shopping?
Yes.
Take her to the doctor appointments, things of that nature?
I've done all of that. I've done all of that and more for her. Around my brother doing dope and shit out there at the house. And not caring about her, really. And with him arguing with her. I've had to stand between him and her. I could be in my bedroom and hear him yelling in there. And I had to stand between her and my brother. Because he gets right up in her face. So I'll bother you. I'm not fighting with my brother. I'm not fighting with him anymore. I don't want to argue with him. He's real sick, and that has to do with part of his anger problems and things like that. I understand that. But learn, get along with him. But don't go along with him. Because when they keep telling you, don't get any drugs out here. I've also told him that I call law. there was any more drugs while after that.
One of the issues that you're posing is you're the brother, right? One of the problems at your home is you and your brother, correct?
Well, it's not so much that, I mean, we're brothers, we love each other. But his choices in life were done. My choices in life were advancing to different things.
Let me stop this, man. He's currently in jail, correct?
Objection, Your Honor. I'm gonna object to this line of question for relevance.
Well, it is relevant, Your Honor, because I'm trying to show if there's any concern about the argument between the two brothers, that it won't be an issue any longer. He's locked up, he's got a plea warrant and then drug charges. I'm just trying to point out that if you were to continue this probation, they would not be that. That was one of them.
Overruled.
So, are you asking the judge to put you back out on probation? Are you telling the judge you'll follow all the rules that you're supposed to?
I'll follow all the rules.
I'll pass it.
Ms. Heisel.
So, Mr. Rice, you heard Deputy Spurgeon testify, is that correct? You heard Deputy Spurgeon testify, right? So if your mother told 911 that you threatened to kill her, she was either lying or misunderstanding. That's your testimony.
Misunderstood. I mean, she don't lie.
So if she told not only the 911 caller, that dispatcher, but the deputy when he arrived on scene the first time, and then again wrote a statement, or had the deputy write a statement for her, saying that you threatened to kill her, you are denying the fact.
I said what I said, and that's all. I would never say that.
And you also denied that you resisted arrest, is that correct?
Yes.
Did you pull away from the officer?
Well, they had me handcuffed, and they were trying to take me out of the front door. And I told them, man, I don't want to go to jail. I said, man, I've got probation. I mean, next week. I said, please, man, he said, y'all let me go before. Why are you taking me now? They me out the door. Pick up carry me to the car.
So Deputy Spurgeon said you pulled your arm away from the median line.
I didn't pull my arm. No, they had me handcuffed behind.
And Deputy Spurgeon said that they had to pick you up and physically place you in the car because you were resisting arrest. That
No,
was
they just carried me on. Man, they carried me out. That's all. Carried me out there and put me in the car.
so you weren't resisting at all, but they still felt it necessary to carry you to the car and physically place you in that car?
Yeah.
Mr. Rice, back in January of this year, you had Mr. Nolan White, is that correct, as your attorney?
Yes.
Do you remember standing in that box right there in January with Nolan White and myself and us talking about the underlying offense of aggravated assault with a deadly weapon, you entering a plea to that?
Yes.
And that offense involved the reckless discharge of firearm, is that true?
That's it.
And that reckless discharge by you led to injury of your mom, is that correct?
That's right. But I had no idea. She was out there in the show.
I understand, you were not charged with intentionally harming your mother, but you were charged with recklessly discharging firearm cause of injury.
Right.
You remember standing right there in that box and us talking about how serious of an offense that is. In fact, that's such a serious offense that it carries 2 years to 20 years for Texas penitentiary. Remember that? We talked about, because of your lack of criminal history, even though somebody had been shot with a gun, that we thought you deserved a chance at community supervision. You remember that? And you remember us telling you at that time that because of the serious nature of that offense, if there were any missteps on probation, that we would be sending you to prison. Do you remember that? Your Honor, I'm gonna pass.
Mr. Stevens, any further questions?
No further questions.
All right, Mr. Rice, you may step down. Any further evidence or witnesses from the defense?
No, Your Honor. Okay.
All right, would you like closing argument, Ms. Heisel?
Yes, Your Honor.
You may proceed.
Your Honor, I understand that this is a difficult situation Mr. Rice finds himself in. However, in January, which was not that long ago, we all stood here, and we all talked about the consequences of any misstep on probation. We all talked about the seriousness of the underlying offense and how if it were pretty much anyone else, they would not receive the opportunity that Mr. Rice received, which is to get probation for this charge. Not even 6 weeks later, his mother has to call police on multiple occasions on a single night because of his disturbances. She reports to police that she believes that he threatened her life by threatening to kill her. He then is placed under arrest for that, and he resists the officers such that they have to pick him up and physically carry him and place him in the patrol car and cart him off to Vance County Jail. Your Honor, we're going to ask that the purpose of this deferred action, which is to maintain full stretch of the Texas legislature's power for 20 years, be executed in this. Based both on the fact that the underlying was so serious and the very short nature to which Mr. Rice was able to complete probation without some sort of violation. We believe that that is the necessary remedy given the facts before us. That's what we're going to ask for. Your Honor.
Thank you, Ms. Heisel. Mr. Stevens?
Yes, thank you, Your Honor. We're going to ask you, Judge, to continue this charge. His mom might have testified, but even through the testimony of the defendant and through the testimony of the detective surgeon, I think the court can see an obvious need for someone to be there trying to take care of it. I'm not making light of these charges at all. My client is not making light of these charges. However, they are misdemeanors. What we're asking, Judge, is that you sentence my client to a term in the county jail as a condition of probation, and then give him a chance to get back out, give him a chance to do right. On the alternative, Your Honor, I'd ask you to adjudicate him guilty and put him on a brand new 10-year probation. Respectfully request that, Your Honor.
Thank you, Mr. Stevens. Any rebuttal, Ms. Heisel?
Just briefly, Your Honor, there's been a lot of testimony about Mr. Rice's mother and their relationship, and how much she needs him at home. And because of her physical limitations, she wasn't able to be here. However, it was Mr. Rice who admittedly inadvertently shot her, but it was Mr. Rice who shot her. And it was Mr. Rice who caused her 6 weeks into his probation, knowing what the consequences would be, to call the police on multiple occasions to come get him under control because she was in fear of her life.
And let me ask, I'm trying to recollect Deputy Spurgeon's testimony. Did he testify that she stated that in accordance with count 1 that he threatened to kill her or to murder her? Did he testify to that?
Yes, Your Honor. He stated that both he believed on the 911 call, but verbally to him and through dictation of her statement to him, that she said, Mr. Rice said he was going to kill her. I don't believe the word murder was actually ever inserted in that, but it's that he was going to.
Okay, so what I'm gonna do is I'm gonna take the testimony and arguments under advisement. We're gonna reset this case. I note the time, and we have a few more cases on the docket, so I'm gonna reset this for the court's decision, and we won't set it very long. You available on September 16th, Mr. Stevens,
No, sir, I will be in Colorado.
in Colorado?
Yes, I don't get back until the 22nd of September.
All right, I'll tell you what, let's just set it on September 30th at 1:30. And if you could, Mr. Stevens, let's execute a reset form. So, Mr. Reisman. September 30th at 1:30. Mr. Woodwide.
Yes, Your Honor.
Mr. Adams, are y'all ready on Mr. Wood and Mr. Massey?
We're ready.
All right, who's up first?
Can't tell.
Who is this, Deputy McLeish?
Sorry, this is Mr. Wood, Your Honor.
All right. All right, this is cause number CR 29-6, State versus Kevin Lee Wood. Mr. Wood, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, full truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Your name is Kevin Lee Wood, is that correct?
Correct.
Mr. Wood, I see here that you were before the court on September 15th of 2020, and you pled guilty to possession of a controlled substance in penalty group 1 between 4 grams and 200 grams. The court reviewed the evidence, found that there was enough evidence to convict you, but the court deferred a finding of guilt in your case and placed you on deferred community supervision for 5 years and ordered you to pay a $2,500 fine. It was during your term of community supervision that the state filed a motion to adjudicate your guilt and to revoke your community supervision. And they alleged in 9 separate counts, various ways that you have violated. Have you had enough time to review this document with your attorney, Mr. Mitch Adams?
Yes, sir.
And you believe you've had enough time to discuss it with him and have all your questions answered?
Yeah, pretty much, yes, sir.
What, was there anything that you don't understand?
So as far as, just, there was a couple of days of back time that wasn't on there, but like I said, I agreed to go ahead and proceed with it.
Well, I'm showing 134 days back time. What do you think is the accurate amount?
Yeah, it's 140 or roughly. I spent a week in Coffin County when I got arrested on this motion to revoke the first time, and then I made bond on it. I've spent a week in jail on that before. Anyways, that's not on there. It's just got my Van Zandt County time on there.
Did you discuss that with Mr. Adams?
Yeah, I did. Like I said, and it's not a big deal. If it was going to be, I asked him if it was going to be, if it was going to delay anything, then we just go ahead and carry on with it,
Mr. Adams, Mr. Woodwhack, have y'all discussed his concern about the back time not being correct?
No, I haven't discussed it with Mr. Woodwhack. Mr. Wood brought it up to me as we were going through his plea papers before today's hearing.
Mr. Wood, Mr. Adams, do you want to take a pause in this hearing and let the state speak with their staff to see if they can determine if he is eligible for the additional credit time?
I'll defer to talk about that. Mr. Wood, do you want to proceed with the hearing today, or do you want to read this?
No, we can just go ahead and proceed with it. Like I said, if it's gonna create any setbacks, we'll just go ahead. I want to go ahead and get it taken care of today if we can.
Well, I'm not sure that it would cause a setback, but you would be, if you're entitled to additional time, then that would be awarded towards your sentence, and that could affect your parole eligibility date and subsequent release by at least the number of days that you've indicated, a week or so.
The question I do have is, more importantly than the back time, is the coronavirus having the TDC chain and everything shut down, or the possibility of it shutting down. Is there anything we can do as far as getting paroled out of the county, or that, do y'all have any control or say so over that at all?
Well, once you receive a judgment, then TDC picks that up from today. Okay, so any credit time that you get from sitting in the county jail goes up until yesterday, and then the day of your judgment starts with the TDCJ accounting. So if you sit in jail, let's say that COVID shuts down for a year, the TDCJ shuts down for a year due to COVID, then you're going to get all of that back time, and TDCJ would be accounting for that even though you're housed here.
Right, but I mean, will I still see parole like I would if I was there?
Parole does come to the Van Zandt County Justice Center, so I'm assuming that you would see them. And if you became parole eligible and they wanted to release you, I think we have had inmates that have been released from TDCJ custody who never went to TDCJ custody. They're in the Van Zandt County Jail.
Because on a 4-year sentence, I'm eligible for parole after 5 months and 22 days, which I'm very close to as of right now, And with the coronavirus shutting everything down, it's just got me concerned, hey, it's just going to get me stuck in here, without seeing parole. That's what I'm kind of concerned about. But
Mr. Adams, do you want to address that at all with Mr. Wood?
Well, he and I talked about it yesterday.
And do we have any information from the jail staff as to whether or not there's a COVID delay on transport to TDCJ?
I don't know of any. I could be wrong, but I don't know of any delay.
Deputy McLeish, could you ask Lieutenant Harrelson to step in, and so maybe we could fill some of these questions with her?
Will do my best, Your Honor. Yes, sir.
All right, so let's do this, Mr. Wood. Go ahead and have a seat. I'm going to bring Mr. Massey up, and then we're going to address your issues, and then we'll bring you back up, okay?
thank you.
Yeah, you better be careful. Mr. Massey, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can put your hand down. You are Eric Robert Massey, is that right?
Yes.
Mr. Massey, are you a United States citizen?
No.
You're not a United States citizen?
I'm tired of one, but I got a sheet from the king. That's what a massive sheet is, an Eric sheet. I was abducted as a child. So I'm Amber Alert, and I can't get anybody to talk about it. So it's in our archive in England. But I got a check, but it's from the king. So I went to England, and I'm an actor, Jason. And that's all I know. That's how I'm getting a check. And I've been working on it, but I'm fixing to start traveling, and I'll get it worked out. And things like Pixar and things, and DeLorean, the metal, and Galvin and things. I've been here, and I don't know what year it was when I got in. Anyway, thanks.
Okay, I tell you what, I want you to,
So all the paperwork just, it kind of floats around, and I've been having problems with a lot of people because they know it ever since the beginning and don't tell them, and they're everywhere. I just can't seem to get away. And it's an orphan issue. It's probably, and they've been under protective custody for a while, but I just don't know. I made that movie with Natalie Portman. That was me. In the police, yeah. And I was like 7 days old, and I was 5,000 pounds and 7'3". That's from getting shot and stuff. I just didn't believe any of my stories. It used to swell up, and it does it anyway. I got really good genetics or something. So I get it straightened down when I get out of here, and I'm getting my first car. And I don't think it made 18 yet. Donald Trump said he'd tell me when I'm 18. And he's on the case. And Barack Obama.
well, I tell you what, let's do this, Mr. Massey. Hey, hang on for just a second. I've got to, something just caught my attention. I need to address real quick. I'm going, I'll be right back with you in just a second. Mr. Adams, Mr. Woodwalk, I'll see you in just a second.
Okay, thank you.
Aaron? Aaron, hello? Aaron? Let's see. Join breakout, right?
Your Honor, you waiting on me?
Thank y'all. Thank you.
Oh, I was gonna get you. I was gonna get you. Dang.
Y'all got to start reading lips. Is Natalia available?
She is, Your Honor. She stepped in, got some information on Mr. Wood and stepped back to her office. She'll be back shortly.
Okay, what was she checking to see, like transfer date, or I was just wanting to know if kind of what the delay, if there was a delay on transporting to TDC, kind of what that lag time is. And Mr. Wood's concern is if he's not at TDC, how does he get to meet with the parole officer so that he doesn't get stuck in limbo here in Van Zandt County on a TDC sentence? I was really wanting to know if she could just tell us if TDC sends parole over here and if they parole people from Van Zandt County when they can't be transferred to TDC.
She actually indicated on the web that there is no delay with TDC right now.
Oh, there, okay, good. I didn't know if there was or not. So I'm just trying to help Mr. Wood here. He had a couple of questions. And so did you hear what I was saying to Aaron, or did you just walk in?
I walked in on the end of it.
Okay, so Mr. Wood is going to take a plea bargain today for 4 years TDC. He's already got about 130, almost 40 days credit. So he had a couple questions. One, well, really his most pressing question is if he accepts the sentence and he gets a ticket to go to TDC, and if TDC for some reason in the next week or two pops with a COVID and says, hey, we're not transporting people, we're quarantining, how does TDC regulate their offenders who are being housed in county jails such as ours, to where can he meet with parole, and do they parole out of Van Zandt County if he never makes it down there?
So I will say, to begin with, the sooner I get the pin packet, the sooner I get it sent, the sooner I get a ticket. So that if I get that within a week, typically I get a ticket within 3 weeks. It's actually a pretty fast process. The longer it takes for me to get that pin packet, the longer it takes for me to get a ticket. I don't know why that is, but that's what I'm seeing with the data that I'm keeping up with. They're not going to stop intake. They change units when they shut down for quarantine, but they will not stop intake, and they do not PIA from county. So he cannot parole without going to TDC.
Have we had an instance where they were refusing intake back during the height of COVID back in 2020 in March? Do you have any experience with that, where we had people that couldn't go to SafeP, they couldn't go to Gen Pol, they couldn't go to anything?
No, it's my understanding that they shut down the units they were having issues with. And instead of having 10 intake units, they only had 2 or 3. They didn't stop the process. It was slower.
Okay. All right, Mr. Wood, does that help answer your questions? And
a little bit. Don't really give me much. It does, it clarifies it a little bit, but it doesn't make me feel much better as far as, the fact that I might get stuck, because I'm on a 4-year sentence. I'm up for parole in 5 months, 21 days, and if my time was starting today and I had 4 or 5 months to sit here or whatever before my time started, before I seen parole, because, they're not going to come see me out of this county. But if I can, is there a way to guarantee that I'm going to, be on the next ticket out of here?
No, there's no guarantees. There's no guarantees because we don't control you being shipped to TDC. So what Lieutenant Harrelson was saying is, whenever we get our pin pack, that's all your paperwork that has to be submitted for issuance to TDC for them to issue a ticket for you to be picked up, processed in intake. The sooner we get that, the sooner she can get it done. And she said it takes about a week to get the pin packet. And then after that, it's been taking about 3 weeks. So about a month is probably all you're looking at on average right now. So you've got 130 days. So, that's not even a little over 4 months. So 5 months, you might be right at parole eligibility, but that assumes that you would parole on your first your first time, and I don't know what your criminal history is. I don't know, but do you have criminal history? Do you have criminal history?
Misdemeanors.
Misdemeanors, you don't have any. Have you been to pen before? Never been to pen? Okay. So no, I can't guarantee you that. So, but you're on.
Can you put a word in for me to be a trustee until I pull chain?
Well, I don't put in words because I don't monitor your behavior and all that. That woman to the right is going to have a lot. I mean, she's going to have the most pull there on what happens with, trustee and all those things. So, but if you don't take the deal and you want to just wait to see what happens, there's no guarantee that your case is going to get any better, that you're going to get a shorter sentence, that you're going to get out sooner. So
I've already signed it. I've already signed my paperwork. I'm ready to go. That's it.
okay.
So-
Well, I understand your concern though. I do. All right. So do you want to go forward?
So
Okay. And like what she's saying right now, Lieutenant Harrelson's saying that she doesn't see any reason that it's going to be delayed and prolonged. So hopefully that won't be a problem at all. But, if it is, then, I'm sure I can keep in touch with Lieutenant Harrelson on that. And if there's anything that we can do to help, set up a Zoom for parole or something like that, we can do those things. Okay.
So, thanks, sir. Mitch, thank you.
Okay.
Hopefully we don't see each other again.
Well, hang on, we're not done yet. We're not done yet. So we're just in the middle. We're in the middle. So thank you, Lieutenant Harrelson. I appreciate you.
Judge, do you mind me answering a question for him?
Sure, go ahead. Sure, go ahead.
About your time credit,
Mhm.
they're giving you more credit than what I would.
Right. Well, I got a week in Kaufman County before I came over there last time I got arrested. That's where I was coming up with the
According to my record, this is the credit that I would give you.
right. In Vance County. Right. Thank you. Okay.
So, Mr. Wood, if you want that additional 6 days, we can. Reschedule.
Nah, I'm ready to get it signed and get my ticket out of here.
Okay. All right. So I think where we were at last time is I asked if you understood all the paper, you had any questions. That's when the questions arose, and I think we've addressed those. So you understand you're still under oath. Are you pleased with Mr. Adams' representation of you as your attorney?
Yes.
Okay. And Mr. Adams is Mr. Wood going to waive the formal reading of the state's motion?
We do, Your Honor.
And is he going to plead true to all counts?
That's correct, Your Honor.
Okay. So what I would ask you, Mr. Wood, at this time in reviewing the state's motion is how do you plead to counts 1 through counts 9? Are those counts true or not true?
True.
True. And are you pleading true because the conduct alleged in those counts is true and you're not just pleading true to get a certain deal?
Correct.
Okay. Then, and has anyone threatened or forced or pressured you to plead true today?
Not today.
No? Okay. All right. Then the court will accept the defendant's plea of true. At this time, Mr. Adams, any objection to State's Exhibit A, the defendant's waiver of rights and plea of true?
No objection, Your Honor.
All right. State's A is admitted into evidence. Court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Oh, Your Honor, we would rest and close.
Anything further from you, Mr. Adams?
No, Your Honor, we rest.
All right. Then, Mr. Wood, based on your pleas of true, the court will find each count to be true, find that you have violated the terms and conditions of your community supervision. Court will follow the plea agreement that you've reached with the state. Court hereby adjudicates your guilt, convicts you of possession of controlled substance in penalty group 1, 4 grams to 200 grams, second-degree felony. Court assesses your punishment at 4 years confinement in the Texas Department of Criminal Justice Institutional Division. Orders you to pay the balance of your financial obligations. Court awards you 134 days credit towards your sentence for the time that you have spent in jail on this cause. So whenever you do get out, and when you do make parole, I'm going to order you to report back to the Van Zandt County Courthouse so you can make arrangements to discharge your fines and restitution and court costs, okay?
All right, yes, sir.
All right.
One more thing, Mr. One more thing, just, I caught a charge out of Wood County that was supposed to be taken care of with all this stuff too.
Well, we don't have jurisdiction over Wood County charges. So any business that's, arises in Wood County has to be handled by their authorities over there. So The only thing I could do is have any sentence you received in a Wood County charge. I could order my sentence to run concurrent with that sentence. And right now, it says this sentence shall run concurrently. So, but we can't resolve anything out of Wood County.
This is a more severe charge than that one, so everything should flow right on through, correct?
Well, if Wood County wants you, they will have a hold on you, a detainer.
I'm out on bond.
If you're on bond, well, that they may bench warrant you back from TDC. Okay. All right. So I'm going to hereby remand you to the custody of the sheriff and have you go with the bailiff to be fingerprinted. Good luck to you, Mr. Wood.
Yes, sir.
Put this down, sorry, that you got on the table.
All right, Mr. Adams, you got anything further for me?
Oh, Judge, I know. Need a
Thank,
drink.
thank goodness. Yes, I'm coming to your office right now.
All right.
Don't go right now, because I'm coming to your office right now.
Oh, well, that makes me go quicker.
Run, Judge, run.
All right, gentlemen, appreciate it. Thank you, Aaron. I'll see you in a minute.
Thank you, Judge. Thank you, Deputy Aaron.